It's not permitting the petitioner to participate in the counseling in the course of MBBS course for the year 2023-24.
You supply a copy to
Their
Mr.
conference is closing today itself. Open today.
Supply a copy to Mr. Rao. We will take
Much
up.
of it. Much.
My Lordship, this is regarding MBBS admissions. MBBS admissions, my Lordship, for NCC quota. So already the petition was numbered.
NCC quota.
Yes, my Lordship.
You know what is the result NCC quota. Get the judgment. What you are NCC A certificate.
No, my Lordship, I am for the B certificate, my Lordship. Yeah. So it may be for lunch motion because already interim direction was then I have filed IA also, my Lordship, for the advancement. Urgency.
What is the urgency?
Urgency
Except
is-
that you are.
Urgency is, my Lordship, like if this hearing is not happened, the petition will be infectious, my Lordship. Because there is a last quota today.
So what is the urgency?
Urgency is about the admissions, my Lordship.
All right, give it. You know the judgment which we have.
I have, my Lordship. I've seen.
SIC Act, my lords, challenging the
Surface.
against DRAT order, my lords.
Fresh matter.
My lords, fresh, my lords, it was adjourned by 3 weeks, my lords. Thereafter, it was not listed.
Not listed. What is the, why do
For
you want
orders and
it listing
admission,
for final hearing?
No, my lords, for orders on admission, my lords,
We'll take it up.
any day,
Today is what, 19th,
19.
21st?
Subject to your lordship's kindly. My lord, public interest litigation of 2016 on the last
What is
occasion.
the urgency? Final hearing? No urgency.
My lord, expedited petition is filed for fixing of date. My lord. That may be taken up. My lord.
What is the urgency?
My lord, it's a protection of hillock. My lord, it is being occupied by third parties. Interim order has
Hillock?
expired.
Which hillock?
Hillock in
All right.
Jadchala Mandal, my lord.
23rd
23rd. Much of.
for fixing a date for
Yes,
hearing.
my
No,
lord.
not
Expedited petition is filed.
Subject to corruption, matter pertaining to interstate transfers. But both the
no, what fresh matter? You have filed
notice
when?
already issued. Notice already issued. It is supposed to be listed on 6/9, but is not listed.
What is the urgency?
The agency, they made a request for the transfer from AP to Telangana. But the state government issued consent.
23rd September, Saturday.
Much of it.
They will, you know what they will do. They will ask time to file counter.
No, but already similar matters are disposed of.
Disposed of.
Much of it.
Okay. Huh?
Yes. In jail or no part of ours.
Why?
But she was not responsible. It's about
No, but you have filed it today only. What were you doing for 20 days? Tomorrow?
That's the matters pertaining to promotions of teachers, school assistant teachers to graduate masters.
Fresh matter.
Yes,
You have complied with office objections. It should be listed tomorrow then. All right. Thursday, 21st.
Lordship, in this matter, I'm appearing for the respondent. The writ petition was filed in 2021 and as interim stay was granted in December 2021. We filed a vacate stay petition, but after that it was not listed so far.
22nd September. Yeah.
May I please?
Yes, Mr. Reddy.
Millet, against the very same impugned order, Millet. The first respondent has filed an appeal and your lordships have caused an interim order and directed to cause an inquiry and report to your lordships.
There's a difference, my lords. If state has completed, I may bring to your lordships notice the difference in both the cases for a moment. My lords, in that matter, lordships have heard a contempt appeal wherein my lords have held that the undertaking which he had given not to construct, that not to construct has to be ascertained by an independent authority.
Yes.
What my lords have done so.
Yes.
My lords, thereafter, JNTU head of
We
department.
will list it along with CX.
It's a small difference I may point out and then I'll
We will list it along with that case.
Yes, just one small difference, if my lords may pardon me for a moment.
No question of pardon, Mr. Reddy, you are well within
Well,
your right.
because if you're not-
We are only saying that since a similar again
Yes,
same
yes.
order, writ appeal has been entertained, contempt appeal,
Yes,
we are only listing it with that.
the reason,
Nothing, not
the
doing
reason
anything.
why I am submitting in this manner is that in that contempt appeal, my lords, the appellant informed your lordships that I have not violated the undertaking and I have not constructed. In this case, the commissioner in his counter and as noted by the honorable court holds that after the undertaking construction has taken place, but I only partly demolished. So when the court asked,
So, Mr. Where is the order directing demolition?
There is not.
Where is the direction given by the judge directing demolition which the commissioner has not complied?
the initial
Where is
notice,
the order? Please tell us.
my lords, the notice initially given said that do not construct.
No. This is contempt of courts
Yes.
proceeding, right?
Yes.
There has to be an order and there should be a willful disobedience of that order.
Why?
Where is that order?
My lord, lordship may see page 114 for a moment. Page 114.
No, order.
I'll come to that order, my lord. Just for a moment, see the notice. It's a notice.
See, it's a strange, right? It's his appeal. You are arguing, we are not passing any effective order. We are saying that we will list it along with that contempt appeal. We don't know what you are arguing for. All right, go ahead.
Let's only
So you sit down, Mr. He has taken upon himself the job of making out a case for you.
not
140, yes.
14.
14, yes.
It's a notice for demolition which was stayed by the Honorable High Court by the interim order. Once the notice of demolition is vacated, the interim order, the order of demolition comes into being. Well, lordship may please see.
No. So, no, but we are deciding whether or not they have violated. You are not telling the order. They have violated, the commissioner has violated the order dated 27/10/21. This is the scope
Yes.
of contempt.
Yes,
Learned single judge has held and has sentenced him to
that
this thing.
instruction is going on as per the submission of the petitioner, my lords.
No, but where is the direction to the commissioner which he has violated? Please tell us.
Yes,
We are
sir.
again asking me.
Page 114 for a moment, if my lords were to just bear with me for a moment. Page 114 is
We
the
are seeing 100.
just for a moment.
Yes, sir.
Page 114, then I'll. Well, what happens here is, and here there may be an indication of what was the stage of construction on that date. My lords have directed JNTU to do so. Their note file will also tell your lordships as to what was the stage of construction. This whole problem is arising prior to the undertaking. What is the state of construction? Municipality is stating here that only ground plus upper floor is there. Note file can be.
Demolition.
I'll just read, my lord.
No, he is not, that's why he is not reading.
Just for a moment, my lord. I'll just.
We are just wondering why you are not reading the order despite being asked. Because there is no direction for him to demolish.
Notice of demolition is stayed. So he not once he vacates it.
He has taken the task of making out a point for the appellate. That's why he is arguing. What can be done? Yes.
Just take only half a minute, my lord. Page 114 for a moment, lordship may see. It has come to the notice of the understand that you are constructing cellar plus ground upper in so and so, contrary to the provisions of so and so. You are directed to show sufficient cause by a statement or by an agent in this behalf why the above deviation plan should not be removed, altered or pulled down. Directed to stop work forthwith and submit a reply. Further action will be taken to remove, alter or pull down the deviated portion so and so. This notice of demolition was stayed by an order of this honorable court, my lord. That order came to be vacated upon an understanding by the court that no further construction will be done, my lord. That order of this honorable court, I'll just take your lordships to. It is at page, lordship may please see the order at page 44, my lord. At page 43 and 44, only for a moment.
Mr. Reddy, on the lighter side, if so much by inferential process and arguments a case for contempt is required to be made out, that itself according to us is a fit case for admission.
My lord, lordship may, I'll take your lordship directly to the order of contempt.
Where is,
With regard to the commissioner's action, my lord. Because
Why he has been held guilty?
he has been held guilty because in the counter he says that in spite of the undertaking, construction was going on, but I only demolished it partly. And our lordships asked him, why you're saying like that? Why did you demolish it partly? He says he gave me a representation. Say the builder gave me a representation saying that the building permission was not completely rejected. Lordship, may please see the order for a moment. There is much to be noticed in the manner in which the commissioner has conducted himself, my lords. How, why did he demolish it partly? There either has to be full demolition or half demolition, my lord. Please see, para 7.
He should not have demolished at all. He
Yes,
would have been saved then.
it would have been said, but having demolished it partly,
Partly, therefore, he is liable to go to jail for 6 months.
please see, my lord, it is relevant to know, second respondent being commissioner of instead of demolishing unauthorized structure, by following the procedure, demolish the structure partly. Now what happens is he files another counter saying why he demolished it partly. Lordship will see that counter, my lords, at page 100 to 120. Then he says the builder told me building permission was not completely rejected. Well, it shows the connivance and the collusion between the builder and the commissioner, my lord. Page 113 only for a moment, Lordship may see. Either you demolish or you don't demolish. But why? Page 111, my lord, Lordship may see, para 4.
He is this appellant before the commissioner of municipality. Yes.
Page 111, he explains why he partly demolished also. Para 4, my lord. This is his second counter. It is most respectfully submitted that while order stated so and so, this honorable court has directed the second respondent to explain as to why illegal construction in the subject property has not been demolished completely. This is because he has said that it is construction was going on. In compliance with the said direction, second respondent submits that when the demolition of the illegal construction in the subject property was in progress on 26/11/21, first respondent, who's the builder, submitted a representation dated 26/11/21 along with certain documents to request not to take coercive steps on their building structure until their application for permission is completely rejected. What is this complete rejection, my lord? Because the order of rejection is at page 63 to 64, the building permission. Building permission is rejected. That's all the authority says. But what is this new invention of complete rejection? And somebody comes and says, sir, my building permission is not completely rejected. Don't demolish, go ahead with demolition. I say, okay, demolish completely. There, my lords, his action, because that speaks volumes about the manner in which he conducts himself. Because lordships have heard municipal matters so many. If they give that much levity to a citizen, just because I come with a letter and say, my building permission was not completely rejected, there is some doubt, please do not demolish it completely. Plus, thereafter, he goes on to say, just for a moment, Lordship may see, due to this, the municipality were to make further inquiries on the said representation, and therefore, municipality could not proceed with further demolition. By that time, respondent has made above representation, has demolished the structure partly. After representation, first respondent in view of the applicant municipality stopped further demolition work. This is in furtherance of his earlier counter in which he says that in spite of the undertaking and in spite of your lordship's order, he's going ahead with construction. Therefore, I want to demolish page 78 for a moment, lordship may see. Only for a moment, page 78. It is this para which I want.
But this is not for final hearing, right? You are arguing to such a extent. Are you on caveat?
No, my lord.
Then advance copy.
What I'm trying to 78 for a moment, I'll leave it there.
Yes.
For a moment, 78.
You are for advance copy for respondent. He is not arguing his case. You are making out a case for him. Yes.
In spite of the observations of the court and his counter, in the contempt appeal, he is saying these representations were right. only small submission, Madam. He says these representations were right. I acted correctly. If I were the authority, I would have rendered an unconditional apology, then I would have had no argument. But he says his conduct is right because in accepting such a representation, he has acted correctly in accordance with law. It is that action of his in the grounds which Lordship may take an exception to, because having held that there is violation of the High Court order, para 5 Mellors, in reply to so and so petitioner submitted representation, first respondent is proceeding with illegal construction in violation of his undertaking. Requested to take accordingly, respond municipality has issued notice dated 14/10/21 directing to stop further construction. This is when the order of the Honorable High Court, single judge's order was pending, reserved. And if any construction is made in violation of the Honorable Court order dated so and so, necessary action submitted in spite of giving. Please see, Manoj, this is here on oath he has given an order affidavit. In spite of giving undertaking before this Honorable Court, Manoj, in spite of giving undertaking before this Honorable Court and issuance of notice to stop work, first respondent continued with the construction. This is what the commissioner is saying, Manoj. He has continued with the construction. After noticing, municipality seized material, warned first respondent not to construct. After dismissal of the writ petition, has taken action by demolishing the structure. He goes ahead with demolition. While demolishing, the person comes with a representation and says, don't complete demolition because representation for that, it has not been completely rejected, has to be considered. Then he stops the demolition. Well, my respectful submission is, if government authorities conduct themselves like this manner, this clearly shows connivance. That's all I'm submitting. Because, my lords, if your lordship were to call for the records of the municipality, then I don't know after 6/9/2021, how can any authority say whether construction has gone on or not? But if the record of the municipality is seen only for a moment, my lord, when that notice was given, the notice to stop construction, one can ascertain what was the stage of the construction. I'm only putting it to your lordship, my lord, if that record is seen. Because when he gave the notice, they will notice all the relevant features and the stage of construction. If that record is placed before your lordship, much light will be shed, my lord. Only that's my respectful submission. The record is placed because, my lord, notices are not given without the note file. Note file may have the complete picture, my lord. What was the stage of construction? Because when the notice is given, he gives a reply and says, I'm not going to construct. Not when the application is 3 months later, my lord. But when the petition was filed and the reply was given.
Yes. She would not have demolished anything. Yes, this is the agreement. Order. Absence of the this one intentional process of reason. It would have satisfied.
Page 53.
Yes.
Page 48. Page 53 documents. Page 53 of the affidavit. 3 months before this affidavit sign is given. Page 53 of the affidavit, the petition, the owner clearly said, I'm not constructing. So if he's not constructing, the note file of the petition clearly elucidated before your lordship. What was the stage of construction? My most humble prayer before your lordship is, any authority appointed may not be accurately able to tell as to whether after 6/9/2021 construction went on or not. But at the date the notice is given, my lord, by the state, perhaps the legislature will place much light before your lordship as to what was the state of construction. So the people is saying
You
is,
file an appropriate application, we will deal with it. It's his appeal. See, he is sitting down, appellant is sitting down, respondent who is not even on caveat is arguing. You are senior counsel, that's why we are hearing you, mister. What to do? All others are waiting.
that's what
Yes,
let it
you please conclude your submission.
be done.
Huh?
This is always submitted.
All
It's connivance.
on the basis of connivance, a person can be this thing punished under contempt of courts act. Find out. Probably we will evolve a new concept in this thing, contempt jurisprudence. Heard on the question of admission. This appeal. Yes.
Lord, I'm appearing for a petitioner in which matter, my lord.
Huh?
I'm for a petitioner, my lord.
Yes.
Senior counsel is appearing in this matter.
Huh?
Senior counsel is appearing in this matter. Kindly have it in the next week.
After 3 days also you want, what is this, Mr. Application for amendment has been allowed. There is no this thing, no scope for senior counsel to appear.
Short adjournment.
It's perfectly a fit case where you should argue. We will designate you senior counsel for this case. Please argue.
Short date, my lord. He requesting for a short date. Only one adjournment, my lord.
Only one means you are entitled 3 adjournments in law, right? Huh?
Sorry, my lord. Sorry.
Yeah, after 3 days, this is the performance, Mr. 3 days we were closed, right? Saturday, Sunday, Monday. It will come up after 3 weeks. Don't seek an adjournment, right? Don't this thing. Don't make a mention memo. It will come up after 3 weeks. If you are not in a hurry, we are also not in a hurry. We want to hear those counsels, old matters. This is all luxury litigation. You also know. You should have done well to contest the suit. No case, Mr. According to us, until unless it is shown to be barred by limitation, can be interfered with in exercise of powers under Article 227. Your senior also knows. That's why he has not come today. What is your name?
He's in another thing.
That's why better place.
There is a criminal.
He doesn't want to argue this.
No, my lord. There is a
What
criminal.
is name?
Sharat Kumar. Sharat Kumar.
Learned counsel submits that the matter has to be argued by.
Sharat Kumar.
No. Who has to argue? Senior counsel's name.
Sridhar or Sripatra, I don't know.
I think he's senior.
My senior.
No. Who will argue, Mr. This case? Who is Amravati in Amravati? That's what we are asking.
I don't know.
Mr. Raghu, who is on record.
He is unable to tell the name of Mr. Go and tell him what he is not seemingly understanding.
Sridhar.
We are only asking who will argue the matter, who is the counsel who is in Amravati today.
Sridhar or Sripatra, I don't know exactly.
That's what should we do? You don't know The ground for adjournment also.
Exact name I don't know, but my senior.
Why are you appearing, mister? Why are you appearing if you don't know, even know who will argue the matter?
Raghuveer sir knows, sir. My senior is Raghuveer sir. He knows who engages.
Rajiv Rai.
Huh?
Who? Senior?
Raghuveer. My senior is
Raghuveer Rai. Huh?
Raghuveer sir.
Raghuveer sir. Huh? Sir, there is no sir, right? His name is sir. Surname is sir. Raghuveer sir.
I see.
Don't say mister. He is not our senior, right?
My senior. I am respecting
So why are you tell his name? Why are you saying Raghuveer sir and all that?
Raghuveer.
This is what like we have done in weekend. We should have enjoyed like you, right? Roamed them out in the mall, huh? Instead of preparing the case. There is nothing to smile, mister. We are not at all happy with your conduct as a junior counsel. There is nothing to smile.
May it please your lordship.
Yes.
My lord, this writ appeal is filed against the order of a single judge, my lord, disposing of my writ petition despite crucial findings in my favor. The short point for consideration before the learned single judge was whether permission granted by the GHMC respondent number 2 to the respondent number 5 for construction of a second school was in accordance with law, particularly GOMS number 168, my lords. The short situation that arose for filing of the writ petition was that, my lord, there is currently a school running from primary right up to high
No,
school.
but this, how are you agreed that this, whether how many schools should run in the locality, High Court cannot decide under Article 226.
My lords, because
It will for the authority to decide. You have been granted the liberty to submit a representation. Authority has been directed to look into it. When the authority takes a decision, perhaps in exercise of judicial review, you can assail that order on the ground that it is irrational, arbitrary, whatever, mala fide.
yes, my lords.
What? But
I may be permitted to take your lordships only through Rule 4 of GOMS 168, my lords. I can clearly show that this grant of permission is in direct violation of that.
Ideally, the construction can be undertaken after obtaining the facilities. Was paying to this extent may be able to see. They have to first get building permission to construct. See, that we will start this will be in accordance with the land. And we will clarify when just do ground for ingredients is a two schools are 13 students are there. It's considered what carbon dimensions. Photographs. So it's a native school, which is a Mr. Yes, madam.
I may be permitted to take your lordship to the relevant rule, my lord, at page number 58 in GOMS 168. In fact, there's a specific finding given by the learned single judge that even the present school that is running there does not fulfill the norms as stipulated under 168.
58.
Page 58, my lords.
What is this rule, madam?
Rule 4, my lord. This is GOMS 168, my lord, which has been enacted by the government in the year 2012, which regulates the usage of buildings and the manner in which permissions can be granted for constructions, my lord. Therefore, it covers both construction permissions and usage permissions, my lord, for the buildings. At page 58, your lordship would find Rule 4, my lord. Requirement of approach road for building sites or plots. The minimum abutting existing road width required for various uses of building activities shall be as given below. My lord, the relevant rule is B1, my lords, in the table. This is a residential locality located in Amirpet, my lords. And there's already a school with 1,200 students. And now there's permission granted for a new school, my lord, where the road width is 30 feet or 9 meters. And that is the only road to get inside and get outside of the colony, my lord, a residential colony of 400
Where is the
families.
permission granted?
My lord, the permission is at page number 49, my lord.
You will challenge that permission.
Yes, my lords, I've challenged this permission.
So this building permit order is not this thing subject to an appeal under the act.
No, my lords, as far as I am aware, it's not, my lord.
Please find out. We don't think that every building permission granted by GHMC only remedies to file a petition under Article 226.
My lords, I may be permitted to make one submission, my lord.
1 minute.
Respondent number 2, my lord, we have filed a counter before the learned single judge, my lords, after a
We
day.
are asking about appeal
Not appeal,
against building permit order. What is the remedy to an aggrieved person? No remedy.
no remedy. Under the act, there is no remedy. Because the permission was granted to the unofficial respondent. We have filed-
There has to be a provision. Normally, there will be a provision of an appeal. And so far as I have I don't know about this act. Which act?
That's the
TSHC
TSHC
Act,
Act.
my lord, and GO 168.
No one comes to see. Like he is asking us to examine this complaint in writ petition. I don't think there will be a power of supervision control, some authority. Which provision you grant building permission? Yes.
Not 428.
Huh?
428. Section
429.
428
428.
of GHMC Act.
428. Notice to be given? No. No. Where is this, Mr.? Which provision?
My lord, lordship may.
Huh?
Lordship may kindly pass.
Yes, madam, under which
My lords,
provision this?
429, my lord.
Huh?
429, section 429.
439.
429, my lords.
Commissioner may require plan to be furnished.
My lords, once those plans are furnished, my lords, at the
No.
time within the set period, the commissioner may require for additional documents upon which a permission may be granted, my lords.
Where is that? 429. Which subsection?
My lords, at any time within 30 days after receipt of any notice under 428, the commissioner may by written notice require the person any of the documents.
Not there, madam.
Lord, may I, my lord? My lord, 428, my lord, application is made for building permission, my lord.
28. Application will be made.
428 1 minute.
This will flag. All the commission must do is to find out private places. 429. Page 4. Section 430. Here, this is the judgment which is present. That is on 429. So this, see, there has to be an appeal. The petitioner is aggrieved, then he can go for it. That is the case that the. But where is the appeal provision? Any person aggrieved by request aggrieved, he has to see this. So, madam, find out under
My
which
lords,
provision.
application has to be made under 428,
Find
my
out.
lord, of their
You are
intention.
obviously not ready on this.
My lords, may I make one submission, my lords? Ultimately, my lord.
No, no, no.
the-
Please answer the query by the court.
Very well. My lords, your lordship may kindly see the intention of 428, my lord, and including the permission at page number 49. The application is made under 388, 428 and 433 of the HMC Act, my lords. At page
So,
number
under which
49.
provision, madam, this permission has been granted?
My lord, once a notice of intention to construct is given under
No,
428, my lord.
Either there is provision or there is no provision. Don't
Lord,
argue
I
like.
pass over the
If
matter,
you
my
have
lord.
not studied it, that's why we said that please study it and come. You are not ready to do it also.
Your lordship may
We
kindly
will
pass
find
over
out,
the matter.
madam.
Your lordship
You
may
are
kindly
not
pass over
prepared
the
to
matter.
answer. We will have to, he doesn't know, he is the counsel for GHMC, we will send a copy. to the corporation saying that you have engaged a counsel who doesn't know under which provision building permission is granted and is there any provision of appeal, he doesn't know.
28 Malad application is made at page number 112 Malad, the matter was referred to a building committee.
But see, is it our thing job? Yeah, of course it is our job to find out. They won't, they will not. Ah. 54. No, but how can there be that suffering if we refuse to reject? We will examine this.
In fact, my lord, if 428 is read with section 437, my lord. When building or work
No,
may be
madam, we are
proceeded with-
adjourning because we want to study it further.
My
You
lord,
are ready?
I'll make only one
You are
submission, my-
ready, but we are not ready. We have
I'll
to
make one
study.
submission, my lord, and I'll leave it to your lordship, my lord. At section 437, my lords, if within 30 days after receipt of any notice under section 428 or 433 or of the plan section description of further information, if any, called for under 429, 431 or 434 as the case may be, the commissioner fails to intimate in writing to the person who has given the said notice his disapproval of the building which the said person proposes to erect, or of the work which he proposes to execute, or if within the said period the commissioner signifies in writing to the said person his approval of the said building or work, the said person may at any time within 1 year from the date of delivery of the notice to the commissioner proceed with the said building or work in accordance with his intention as described in the notice or in any of the documents.
What are you reading, madam? We told you that we want an adjournment to study it better. You are ready.
To your lordship, my lord.
You are ready, no, but you don't know under which provision this order has been passed. Despite that, you are saying that you want to ask.
My lord, the order has
We
been
don't
passed
want
under-
to see, because of your inexperience, we don't want to write that a query was put to council, she was unable to point out and didn't answer, and therefore petition is dismissed. This is the easiest order we can pass. But
My lord,
we
I
don't want to
apologize
do it
for my-
because of your inexperience. We
My
don't
lord,
want to
apologies
punish,
that I have
and
unable-
both of you are not able to answer the query. So the best thing is we will have to, since we have taken vote to do justice, we have to study, right? That's what you are trying to tell us, that it's your job, do it better.
My lords, I'm sorry, I've not been able to assist
fine.
my lords, my lord. But as far as my understanding, my lords, under 428 read with 437, my lords,
The
empowers the
order-
commissioner.
The petitioner, the appellant had assailed the validity of the order dated
That there is a delay of 156 days in preparing the appeal.
Yes. He will not do like Mr. Mayur Reddy, stand up and argue. You will have to argue. Everything. Once you were lucky, right? Every time it won't happen.
No,
He's sitting
right.
quietly. You are appellant. Argue your case.
I'm only bringing it.
No, no, we are inclined to condone the delay.
Very well.
Yes,
Very well.
now on merits.
The learned single judge has set aside the order and directed that he should be reinstated into service at page 21. It is cancellation of a caste certificate
Correct.
pertaining to scheduled tribe community. This
What is the point in your appeal? According to us, there is nothing.
my respect.
The learned single judge has set it aside on the ground that you have not even taken note of the order passed by
I am before your lordships today.
22511/7. How can you justify this order?
Now, we will undertake the same exercise as contemplated under the earlier judgment, and we will pass appropriate orders. Because that was not taken into consideration was the sole ground for allowing the writ petition.
Mr. Senior Counsel, you will agree to the extent that learned single judge, after setting aside the order, should have given the liberty.
Here in the judgment, did not prescribe any such a procedure or any such a name. It has answered the question. Saying about the people of the community are entitled for reservation. According to
All right. This is a finding. Right. Which page?
Yes, the judgment starts at page
493.
Not 493. It has been quoted here also.
It is quoted here. Page 8. The relevant portion.
Okay. Yes.
the judgment is there in the
No. If you can point out from this, which has been extracted by learned single.
yes.
Page 17, towards bottom.
Third, the order of the learner single judge, page 21 will automatically see extracted portion of the order of the
Page 21.
21.
20. Yes.
Prior to paragraph, again to paragraph 8, the last paragraph of the order. The infant proceeding stands so it seeks to make a distinction between Negadari Goyas of Commitment Malaka districts and Negadari Goyas of Mandapur district or related to recorded cost. Respondent shall receive obligations of recommend members of British Association and other citizens included and consider the case for grant of in accordance with law without placing the rights of the report enclosed to each one order and without further. The repetition belongs to say Negadari Goya from Adilabad. Following the division by judgment, the Indian has set aside the orders necessary to railway the has cancelled. And government did not carry the action to the Supreme Court. The division by judgment of the Shah.
No, but where is the finding that these persons are entitled to reservation? No. This is only considered their case for grant of ST certificate in accordance with law.
Only distinction they want to make out the case of which states who are in Negadari Goya from Adilabad district. Whereas Negadari Goya from Warangal and district alone are entitled for ST certificate, not from Adilabad district. Division then followed has seconded a particular view of the government and then the people from Adilabad district are
Mr.
My respectful submission, is in Adilabad, this Lingadari Koya is not
What you are a mighty state fighting against your assistant inspector in sericulture department. What is this? You channelize your energy in better things, right? Heard on IA 1 of 2023 an application seeking condonation of delay for the reasons assigned in the application duly supported Yes.
Amendment petition.
Yes.
It is against the allowing the writ petition number 18097 of 2017.
Huh?
Writ appeal is filed. There is a development agreement in between the petitioners and the first respondent. It is dated 5/3/2009. As per the terms of the development agreement, the entire process of the obtaining permission, making the land into plots and setting the land all shall be completed within a period of 3 years. 5 years period was lapsed.
Mr. Registration of cancellation deed is contrary to Rule 26K of the Telangana Rules and Registration Act.
Yes.
So what are you arguing?
Before coming into the commencement of the act, it is amended on 2/6/2014.
Yes.
The amendment came into force from Telangana on 2/6/2014. This deed of cancellation was taken place on 29/5/2014. The cancellation has taken place on 28/5/2014. Page number 64, man.
Yes. Anything else?
The cancellation has taken place on 28/2014. Prior to amendment after by the Telangana government, which came into force on 2/6/2014.
Yes. That's it.
No. The prior to
Don't look at us. Please argue.
No.
We are listening to you with all patience.
But prior to cancellation of this deed, I got issued a notice dated 29/3/2014, which is page number 93 to 94.
Yes.
May I read it? Second paragraph. He jointly executed development agreement of general for me in favor of you through registered document also dated 5/3/2009 with a view that you should develop the above said land by obtaining layout, change of land use and the other necessary permission for making of the said lands into plots. This said deal speaks for that you should complete the layout as per the DTCP now with 3 years, with 3 years from the date of the approval. You have not paid any advance. We applied to inform you, despite of lapsing 5 years of time, you have not even applied for layout, change of land use and other necessary permission to make the land into plots. You are not in touch with the other side. Because of your promise that you should obtain all the necessary permission and make the land into plots and to develop the land as per the DTCC norms, we stopped carrying on agriculture and put to loss of benefit from agriculture. Entering into development agreement, your whereabouts are not known to us. Since you have not paid any advance, to us, you are not bothered to take any step to complete the deal. However, we are put to loss. Loss of income, your attitude goes to show that you are not interested in completing the terms of the development agreement. We give you one more chance to apply for sanction of labor, change of land, use, etc. within 1 week from the date of receipt of this notice and get the sanctions. Or else within 1 month and applying and develop the land immediately after.
Hey, Mr. What are you reading? I mean, this you have to meet the reasoning of learned single judge. Reading won't help.
Reading of the issuance of notice prior to cancellation of the deed of
That we have understood. That amendment has come later on, therefore the order cannot be this thing. That's it. Anything else?
No, my submission is, now 14 years are completed. Not even applied for, not applied the consent authority by the first respondent. And the vast extent of the land of 105 acres of the land. After cancellation of the deed of DDBA, we already sold the entire land. And this industrial area is developed. Thousands of employees are working in the industries. And I find the photographs in page number 95 to 103 to show that there is no land. All industries are developed. Huge industries are developed. Therefore, the Honorable Court has not concerned about the issuance of the notice and the non-compliance of the terms of the company. It is a civil dispute practically, because not even applied for the sanction of the labor to the concerned officer. Even today, even after lapse of 14 years, madam. I got a judgment to show that
This intra-court appeal heard on the question of
May I please? It's matter pertaining to no confidence motion, Lordship.
Now nothing.
The meeting was not carried on, Lordship, on 15/9/2023. The meeting was not carried on, Lordship, because of no quorum.
So now nothing survives.
Yes.
Learned counsel for the appellant fairly submits that in compliance
Yes.
of the
That's items 7 and 8 raise an identical question with respect to validity of section 16(2)(c) and 41(2). 16(2) subclause C and 41(2) of the Central Goods and Services Tax Act, as also the Telangana Goods and Services Act.
You are sure that this issue has not been already adjudicated by any court?
Well, there are 6 high courts which are currently seized of the matter. Well, it's including Andhra Pradesh High Court, which has recently taken it up. Well, it's as of now, Tripura, Delhi, Bombay, Gujarat, Karnataka, and AP. 6 courts are seized at the matter. May I just briefly tell you, Lordships, what the issue is?
No, we just, I was wondering whether we have dealt with the issue of validity of section 16 to somewhere, maybe
Not yet,
Karnataka.
not yet, not. May I just draw your Lordship's kind attention to the provisions first and then make my submissions?
Yes, it is on admission in any case, or admission only. Yes.
So it's that this issue arises because of the provisions of 16(2)(c) and 41(2), which make the liability shift from the selling dealer to the purchasing dealer when the selling dealer commits a default. And today, the system is such, when the selling dealer issues a tax invoice, this is reflected in the website of the GST department. On the basis of that, his sales are tabulated, his input credit is tabulated, and it is simply a question of mapping. When I file my return, there is a mapping which takes place, by virtue of which automatically I get the input tax credit. But contrary to this, I have no remedy against my selling dealer who commits a default. On the contrary, statute in 16(2)(c) and 41(2) obligates me to pay. And today I'm virtually hounded because of the default which is committed by the selling dealers.
All right. We'll let it in.
I just want some interim protection because I'll tell you what the difficulty is. In all these matters, the department is going hammer and tongs as if I'm the criminal. And the courts have come to the aid of the petitioners and have protected. In fact, Honorable Supreme Court passed an order in the first instance, which was followed by this Honorable Court, where the court said that even if you were to go in an appeal, there is no determination of tax in my hands as it now. Even if you were to go in an appeal, the appellate remedy can be exercised by deposit of 10%. So deposit 10%. And this has been followed by our High Court, as against which the AP High Court has also granted an identical stay in a matter questioning this. May I pass on these order copies? First, I'll give you the Supreme Court order, followed by the order passed by this Honorable Court, and AP High Court basically because it's an order where identical provisions are challenged before the AP High Court. I'll pass on all three.
Heard on the question of admission. Learned counsel for the petitioners.
This Honorable Court, my lord. The order is filed, my lord, at page 125. Order at page
120?
125, my lord, of the writ petition. My lord, at that stage, the court has said, my lord, insofar as 4 people were arrested, my lord, all of the petitioners from company, my lord, out of which 1 person was not arrested, my lord. So in that case, my lord, the court anyway has granted, my lord, subject to him cooperating with the investigation, no coercive steps are to be taken.
But that's a.
Your lordship is.
If my learned friend understands this order to mean that no coercive steps will be taken.
That's what he.
Kindly say that.
We will say, that's not his statement. No. We understand it operates in different area, but he says that interim order operates in this petition itself. So he's saying.
No, may I make, no, my lord, that is not
the
what I'm saying.
petition is admitted for hearing. Issue notice. Heard on the question of interim relief, learned counsel for the petitioner submits that the learned counsel for the petitioner in support of his prayer for interim relief has relied on an order dated 6/8/2019 by Honorable Supreme Court in C. Shall be taken.
Yeah.
With the submission.
Yes.
Admit the notice, right? All right, 7 and 8. Next.
Obliged, my lord.
Teachers are working in Panchayat Raj department. Panchayat Raj department, local bodies, they are working as teachers. But in the state, there are 2 sets of teachers. One is government teacher, another is Panchayat Raj teacher. But both are governed by different rules. But the state tried their level best to integrate both the services by issuing various rules. Those rules were set aside by the judgment of the Honorable Court twice, as that was upheld by the Supreme Court, and finally we are giving liberty to the state government to approach the president to get integration in pursuance of the Article 371D. But even though they made such effort, President of India granted even permission set aside. Then same was carried to Supreme Court, that is state. The state has not taken any further step to integrate both the services. Therefore, under business rules, government teachers.
All right, so this is a challenge to the validity will.
That's good. Validity. Now we will also kindly take page number 84.
No, we are admitting your petition.
That is insofar as the spouse category is concerned, I am seeking interim relief.
What interim relief?
Suspending the provision 62C.
What circumstance provision can be suspended?
It is not having an authority jurisdiction. It is prima facie discrimination violating Article 14 of the Constitution of India.
That is the main ground. That's why it is being admitted.
That's why pending disposal, production direct to maintain status quo. Otherwise become infectious. Because not one teacher, there are so many teachers. Like the application of the state, it can't be again bring back. Like that, your lordship may.
Nothing. Everybody else except the one who has passed away from this world can be brought back according to us. Not what do you think, Andhra Pradesh, he can't come back?
It is only Milord in
No, but this is not like,
even a
1 minute. Is this, I mean, are you being sent to Andhra Pradesh? A case of allocation. This is, as we have understood, pertains to transfer of teachers.
but only page number 85, Milord. 85.
In fact, similar matter, your lordships have dismissed the IA and admitted the writ petition.
Ah, this is the order, right?
Yes.
We are bound by, you have argued, Mr.
That's I filed. I filed.
This, please see this order.
Yes. That is Milord recently received. Yes. Where
We are bound by this order. We cannot pass a different order in this appeal.
Milord, the same bench, Milord, you asked me kindly take that order. I filed, Milord, you asked me kindly say page number 107.
Yes, yes.
107. But operative portion,
We will pass the same order in your case.
not same order, Milord. Rashmi. Milord, already I filed, Milord, expert petition. Milord, bring this honorable court here, that matter.
That we will consider.
That is one thing. Now we will ask me page number 85, page number 89. We will ask me. This has to be, Milord, they relieved. They should complete. They relieved only, Milord, end of the academic year. Page number 89, para 14, last one. Date of relief and joining. The headmasters, administrators, gazetted teachers who are on transfer promotion shall be relieved from their present place, working up completion of the academic year 2022-2023, that is on 22/4/2023, and he shall join the school where they are posted on 24/4/2023. That has gone. They are not amended. Then you rush me kindly see page number 84, page number, Milord, 84, Milord. Criteria update, para 5. Criteria for transfer postings. The following categories of headmasters, administrators, teachers in the government LP schools. Headmaster, administrators who have completed 5 years of service in a particular school as on 1/2/2023 shall be compulsory transferred, provided those who are going to retire within 3 years from 1/2/22 shall not be shifted. Now 1/2/2023 has gone. Then they amended saying that that is 1/9/2023. But this is the amendment. But the rules, just like they are issuing GOs, the rules are being amended. So last mechanic taking that down. And but the other rule not amended.
Not filed.
But this was recently issued, Milord. After filing, issuing every day one rule. The rule has to be exercised by legislator. They are not placed before the legislator. Earlier, that is a ground to stay, then they may not be placed before the state legislator. It is not placed. Then Milord 14, academic year, the intention of the Milord issuing rules, they should relieve end of the academic year.
No, but you were heard right at length and we have passed an order like this. Can we pass a different order in this case?
Milord, that is true, Milord, but I can't say
You want to argue, you
I
want
can't say anything. Yet I am being criticized because of that. Once Milord, I argued after 4:30, your lordship, Milord, accept
at least argue this.
Yes.
No.
Your lordship
Argue this.
accepted. After Milord, they were dictating, lordship, Milord, omitting the thing. I can't say Milord, because vacation petition. Now we will ask me kindly see whether this is valid or not. First point, Milord, whether the state Secretary Education Department got power to issue Milord these rules. For that, you will also kindly see these teachers. They are government employees. But government employees,
This notification is issued after passing the interim, after modifying the orders.
this is Milord modifying the order. Without Milord passing before the Milord,
Filing this notification separately.
that is different. Milord. After
Why are
filing,
you showing this notification?
after filing, They are not issuing rules just like orders, government orders.
No, it is not before under challenge before us.
No,
we are
yes.
just looking at
Not
it
challenge.
as a piece of paper.
That is not challenge. I'm just bringing it to lordship notice. Now we will also kindly consider whether the state government, the Secretary Education Department got power to issue these rules which are included in this writ petition. For that, the teachers are government servants. For government servants, state and subordinate rules are applicable. Under Rule 38, competent authority got power. For guidelines, you will also kindly take for a minute. You will also kindly take page number 57.
We are already admitting your petition, granting similar order which was granted in other case.
But not similar order, but not further.
We cannot pass a different order. So you will argue till 4:30, right?
No, not like that.
Everybody else is waiting. Please make out your point why other order should be.
Much of it. Yes. Page number 57.
57.
Yes. A. Not 55 or last can take minute. 55. First point, the petitioners are government servants. That is there is no dispute. For us, government servants, state and sub-on rules issued in 96 will apply. In that Rule 38 postulates that who is the competent to effect transfers, what the procedure. Page number 55. Posting and transfers. A member of state service, class of state service may be posted to any post born on the cadre, service or class of service anywhere in the state, provided that such postings and transfers shall be limited territorial jurisdiction of the local cadre specified in accordance with the provisions of President order, where applicable or to the unit of appointment so and so. A member of subordinate service or class of service may be posted another post born on the cadre of such service within the unit of appointment specified so and so. Therefore, we are come under the subordinate service. The competent authority got power to effect transfers. This is the provision. But for effecting transfers, the government used to issue guidelines. So, Rashmi kindly take page number 58. Every year, every time when the government wanted to effect transfers to government employees, under that provision 38, they used to issue guidelines. Page number 58. Transfers and posting of employees, lifting ban on transfer orders issued. Here rule instruction 3. Government after careful examination, consideration hereby relax the ban on transfers imposed by reference first read above for the period from 25th May 2018. So the head of the department competent authority shall follow the following guidelines. These are the guidelines. The transfer shall be made from so and so, so and so. The ban on transfer shall come into force after that. But here, priority, para 3, is number 59. When more than one employee opts for particular place and while effecting the transfer, the competent authority shall give priority in the descending order as given so and so. First, husband wife case only one of the spouses shall be shifted following the prescribed procedure. There is already you got power to issue guidelines as per 38 to effecting transfer. Now, by impugned rules, where even though they have no authority, they are giving 10 points to spouses. Spouses whose the government teacher, whose spouse happen to be government employee, irrespective wife or husband, getting. So the teachers whose spouses are not government employees, not getting forever, and they are depriving. That is discrimination. apart from the competence of the rules, it is discriminated, but all teachers come under one category, one class. Like that, whenever they want to effect transfers, but page number 67, they can issue guidelines giving preference to the spouse, first priority. The impugned rules 05 issued by the education department, as if there is no rule, and the education department has no power. That's why the rules governed by the AP states of rules are existing for us. Then we are coming to impugned rules. How they are not competent. So, Rashmi, kindly see impugned rule. Page number 83. 83. In exercise of the power.
Hey, Mr. This is on interim relief, right? Arguments. This is not final hearing.
We
have, you know that you have argued and we have passed an order. Despite that, you want a different relief. Please tell us why that order should not be followed. And
for a minute, I have shortcut my argument.
Even this section 38, rule 38 has also been argued.
What can be done, Mr. You see our argument. Same council, it's not that different case. Sit down. Yes.
Page number 89, for shortcut, to convince to your lordship.
We will hear you at 4 o'clock because why keep everybody else pending? Right.
4 o'clock.
Interim relief.
Yes.
Interim relief only because we don't want others to this thing. Suffer because of your lengthy arguments. We are only asking, we are admitting your petition, we are granting this interim order, you are seeking suspension. Why? You please tell us. You are the council who have been also have. This order binds you. Despite that, you are saying that we should pass a different order. The simple question is, why we should pass a different order? You are reading page 57, 89. You read like, how does it matter? Let it go on till 4:30. No, please argue. We have changed our mind. Now, yes, let it go on. How does it matter? Everybody will suffer. Wait.
No.
We are doing our duty. Please.
I am not interested to suffer others. Because
page 89.
On the day,
89.
Page 89. Last para 14. Date of release.
Yes, you have already read. We have marked it. 24/3 joined the
end of the academic year. Therefore, your lordship may observe.
No, please, what are your submissions first? Why different order should be passed?
And I will make submissions for that.
Please make.
Yes.
Number 1.
But Rashmi said 4 o'clock.
No, not 4. We have changed our mind.
Yes.
We thought of why we should worry about others.
Yes.
We should be a.
That's why Rashmi kindly see.
Yes. That's why we are.
On that day,
yes.
Land Additional Advocate General argued 2 points. I argued more than 2 points. Then your lordship observed that he argued only 2 points. Why you are arguing all these things? Then
whatever is the order has been passed. That order binds the parties unless it's aside by Honorable Supreme.
That's why these things are not available. Your lordship kindly see page number 83. In exercise of the powers conferred by section 78 and 99, Telangana Education Act 82.
Nobody is disputing that this is an act is not enacted. What are you reading for, Mr.? We are admitting your petition. We have told you why are you reading this exercise of powers under 70.
Problem is that once the transfers are giving 10 points affected before academic year.
Let read, Mr. In exercise of powers. Read everything.
Yes. 82.
Mr. You have to make out a point for grant of interim relief. We don't think that reading in exercise of power 78 and 99 is furthers your case for grant of interim.
Submission is once the rules governed by Protocol to Article 309 of the Constitution.
That is the point to be considered.
These Education Act not given any power. My submission is Education Act enacted for different purpose, not regarding transfers of service conditions of government employees. Government teachers are
No power under the Education Act to make rules.
to issue even rules.
See, this is what you should say.
Yes.
You are reading, so that we understand, right?
But we are already, we are suffered by one order. Therefore,
No, suffered means according to you, whatever it is, but this you challenge
yes.
until less it
Because
is.
we feel nervous to make all these things. That you will actually kindly understand your advocates. The statement, page number 72, the main objective of the enactment of the Education Act is not regarding service conditions of the employees, the teachers, government teachers, the private colleges. See that statement of the reasons, consequent and taking up the responsibility of the paying salaries, etc. The member of the staff, the beginning page number 69 is the original act. Page number 69. At present, education administration in the state is broadly governed by the executive rules and cadre and in few enactment to meet some special requirement. The Andhra Pradesh Primary Education Act 1961 providing free and compulsory primary education for children in the state has resulted in a unprecedented upward spiral and fuel and enrollment and consequent pressure. The spread of secondary education, which enrollments nearly quadrupled over the first 3 plan year. Secondary Education Act, secondary education has in turn given an equally power push for the expansion of college education. Experience in recent years has brought forth the expectancy from more comprehensive and legally valid measures in order to make the future education administration more effective and fruitful. As a sequel of such significant developments, there has also been large-scale changes in the academic requirement, which has made nearly absolute and existing textbooks, teaching method, supervisions, regular study system and examination, teachers training, school organization, grant in aid, pattern, teachers welfare. This situation naturally calls for the revise the continually rising standard in these key areas of education administration. Further, the existing rules have been called in question in court of law as not having the necessary statutory backing. They are also not comprehensive enough to deal with the aforesaid significant development and have also proved ineffective in actual implementation. It also therefore become necessary to confer by law adequate power of the concerned authorities to deal with the change in situation. The Commission on Education, Kotari Commission.
Council, see, you're reading the entire statement of objects. We are clear about it. It's nothing but waste of time. Already there is this petition has been admitted earlier. Orders have been passed. And matter also requires a detailed counter. The admission stage, you are arguing entirely as if it's a final hearing.
Otherwise, it become infectious, because my respectful submission is not one transfer. Even one transfer is affected. Finally, it can't come back. That is the situation.
No, so therefore you will read the statement of objects reason.
Why, I am reading your
We asked you, Mr. that you please give your submissions 1, 2, 3.
Yes, right.
Why different order should be passed in this case?
Yes.
What happens to Supreme Court's the decision which says that in the same case similar order should be passed? Why it will not apply that principle?
Yes.
Tell us.
No.
We are asking you now. Madam, 95 supplement 1 SCC get 465. Yes. Yes.
Now, this act, first I'll only make without reading anything. This act is not.
You are such an experienced counsel, Mr. You should be in the fingertips. These are the point 1, 2, 3. Therefore, different orders should be passed. You are reading. We are lost in reading, unable to make out only one. This thing you have said that the state government has no power under Education Act to frame the rules. That point.
I will go straight.
Other point.
I will go straight.
Tell us that why different order should be passed in your case. Earlier order is wrong, absurd, right? According to you. But this is binding on us.
Your last step not gone through. Your last step not appeared.
This is Mr. Then the result is not that one order is not to liking, then file rate petition through another 3% and then again re-educate. This is not.
That is unfortunate thing.
No, this order should be challenged in a higher forum.
But I got the order not 3 days back, even though that
Please file then. Also this, take this order also which we are going to pass.
My only point is,
95 supplement 1 SS.
your lordship not examine the validity of the rules.
In the previous order, validity is not, validity will be examined at the time of final hearing, which is in this petition which is pending. Validity of rule.
What? 6 to C. 6 to C.
So this has been decided, this writ petition. This writ petition has been decided.
Not decided.
Yes. It will be.
So time of basic conclusion.
Time of AC validity of rule 6 to not examined.
Not examined.
Then.
Therefore, but here I am not bringing to lordship notice that provision itself is violating Article 14 of the Constitution. They are discriminating the petitioners whose wives, whose spouses are not government employees. And giving the 10 points transfers to the spouses, to the teachers whose spouses are government employees. That is a discrimination. Time of AC, my submission is, this is not violating Article 14 of the Constitution.
We have noted down. Yes, next step. It should be stated. Therefore, the rule should be stated.
That part has to be stated. That is one thing.
That's simple, right? Simple submission, right? This you could have made in 5 minutes. You are not this thing making submission. This simple submissions you could have made in the beginning itself. And therefore, it should be stated.
That is because that's
you are reading statement of objects and reasons, Mr.
Yes.
That's it. These are the 3 submissions.
It's not second. Not they have no power.
The first is no power under Education Act. Yes. You were told. Yes. That's it. Third, Mr. Whatever, so and so on the question of admission. Yes.
Page 63.
60. 63. 63.
Lordship's order. Following the orders gotten earlier.
No, but correct. But this was 22. You have approached it after 1 year.
This case is also same, true, there is a delay. There is a delay. That in this case also 26/9/2020 challenge law, page 63 also.
What is the order?
They have not affected, the allotment orders issued to GOMS for 3/1/13. They have not been disturbed below so far.
So we'll say status quo
Yes.
as it is
Yeah.
today. Heard on the, heard on, you are there in this caveat, item 10. No, you file implead whenever. Heard on this thing, heard on the question of admission, so and so, learned counsel for the petitioner submits. Yes. Petition is admitted for hearing issue notice.
My lords.
Same order 12. Yes.
My lords, with permission, my lords, is interim, pardon me, I haven't heard, my lords, is interim application allowed, my lords?
Argue interim application. We have admitted the petition.
Much obliged.
What interim application?
Seeking stay from the
Pay the amount.
protection from the
Pay the
department.
amount of 2,42,481. We don't want to grant stay.
Lordship, it's item 12, Mano.
My lords,
11.
my lords, I apologize, my lords, but
Please argue. Why stay should be granted? Please argue. What is the irretrievable prejudice which will be suffered by you, and whether respondents is at flight risk and they will run away with amount of 2,42,481.
my lords, because there is another matter for the period 14-15 which was listed today before, which we asked the registry to direct the matter to be listed before this court, my lord. There is huge implication of tax amount in another matter, my lords.
Is it recurring? Is it recurring year after year?
My lords,
The tax demand recurring year after year. They can pay 2,42,000.
this is for the period 15-16, my lord. The matter which was listed in court 2 is 15-15, my lords.
We don't know. You argue why stay should be granted, Mr.
My lords,
You said that you have not been heard. Please argue why stay should be granted.
my lords, I apologize because
No question
here,
of
my lords.
apology. Please argue why stay should not be granted. Please tell us.
My lords, I seek stay here. The issue here in this case is, my lords, for the issue is squarely covered by this honorable court's judgment in Sri Sri Engineering, my lords, where this honorable court has held that the Telangana Amendment Act, that is 26 of 2017, lacks the legislative competence, and thereafter this court in the batch of petitions in July 22 has allowed the view of the SSCs and held.
What is the citation?
My lords, it is at page 182 of
Citation. Citation is not 182.
What, my lords?
Citation is something else.
Yes, my lords. 22 bracket 7 TMI 40.
What? All right, find out, Mr. Who appears for respondents. Covered.
Yes, madam. But directly they appeal is avoided without approaching the tribunal. Directly they came to this court, madam.
You are a standing counsel for a right.
AGP for commercial. AGP, madam.
Validity of second amendment, Telangana, value added. Right, we have to tell Mr. Praveen Kumar, this is the PT, right? That we have to tell him what is the provision. Then he will, doesn't know how standing counsels are appointed. like this. Him. They must watch his performance. Like he doesn't know what is. See, validity of Mr. Praveen Kumar, validity of Telangana Value Added Second Amendment Act 2017 has already been adjudicated by this court. That he doesn't know. He said page 183, right? So same this thing. So this petition has to be allowed. He doesn't understand. He's saying without appeal, they have come here. This is the submission.
My lord, SLP.
Which appeal?
He says SLP, but we prefer SLP, my lord. It is pending in Supreme Court.
Please ask him what is the date of order, any order passed, notice issued, when SLP filed. Please ask him, Mr. Praveen Kumar. We will appoint you as amicus for this court, Mr. Praveen Kumar, right? Because we don't want to waste our energy in dealing with such people. There also, we did it in Bangalore also. One government advocate, so far you are now amicus, we will deal with you for these people who don't understand. SLP number?
But SLP mirror 15346.
15346 of
22 minute.
22.
22. It is registered 922.
Right. Is it pending?
Yes, right. Admitted on 28/3/2023.
But delete. Learned counsel for the petitioner submits that the validity of Telangana Value Added Tax within bracket Second Amendment Act 2007.
Obliged powers.
May I please, Lordship? Lordship, the present writ petition is filed challenging the violators of section 13(1) of the VAT Act, my lord. Lordship, in a similar cases, my lord, this honorable court at page in WP 22573 at page 84, my lord. This is a similar case, my lord, wherein this Honorable Supreme Court and has confirmed the order passed by the Delhi High Court in a similarly placed condition, wherein the right to claim ITC has been denied on the for the default committed by the seller, my lord.
Mr.
My lord, I'm opposing on two grounds, my lord. My lord, this writ petition is filed after availing the statutory remedy and has come after the limitation for filing the appeal as expert, my lord. If he was challenging the provision, my lord, he should have come within the time, my lord. Secondly, my lord, the issue directly involved is now adjudicated by Supreme Court in March 2023, my lord. I have a judgment, which, my lord,
you place on record.
Yes, my lord.
In this writ petition, validity of let's see what.
Yes.
13, 14, 15 go together. These are the matters your lordship will recall. These petitions are filed against the orders passed by the NCLT.
Yes.
Wherein, after noticing the fact that the financial creditor has approved the proposals for the private.
Your application for implement has been rejected, right?
Implement rejected, exclusion of lands have been rejected. Both. But your lordships are aware the 5-member bench station also have placed on record, as your lordships have seen along with the paper book, wherein they said the inherent powers can be exercised under Rule 11, the NCLT rules, and the court has power to recall its order provided.
No, but why you should not file an appeal? No appeal lies.
But appeal would lie under 61, but the reason is that once the tribunal has held that we cannot adjudicate on these factors, well, there may not be any purpose served on the appeal. And
you can, same argument you can raise before appellate tribunal.
But insofar as interpretation of the statutory provisions, your lordship perhaps would be in a better position to appreciate.
No, Supreme Court would be the best position to appreciate. Will you file straightway? Because best position, you can't do it.
NCLT is in between before Supreme Court. Your lordship will kindly see page 185.
We are not inclined, Mister. What do you say with regard to this? The settled rule is extraordinary, discretionary jurisdiction, availability. All these special enactments have been, the provisions have been made for that only.
Your lordships have seen on the earlier occasion when it has.
No, we don't want the Supreme Court to criticize that High Court should not have dealt with the controversy on merits and should have relegated the petitioner to avail. You still have the 226 open after NCLT also.
Orders of office note, your lordships have
gone into what we, Mr. Sorry, this is not correct. This is what we have said, that we agree with the submission that if the office refuses to register on alternative remedy, it cannot do so. The court, it has the, we have not adjudicated anything admitting your petition. Please see the order. Please see the order. Please see the order. Please see once and then argue. We have only said that we have to decide the question.
What all I was submitting for your lordships on the last occasion also is, it falls within the exceptions as enumerated by the Honorable Supreme Court in Whirlpool.
Why it is void? Natural justice, void. What 3 exceptions are where provisions of statute are under challenge. Number 1, where the order is void and same has been passed in violation of principles of natural justice. 3 exceptions. How? Which category?
This order, if your lordship perceives,
void.
It has been passed in violation of natural justice for the simple reason that the facts that have been brought to the notice of NCLT is.
You have not been heard.
Which not been heard on the merits of the matter to state that after the adjudication, after admission of the CP, still.
Actually, when the IRP is appointed, he is going to assume the agreement.
At page 48, 6.16, your lordship will kindly.
Which ground you have taken that you have not been heard? Violation of natural justice.
I mean, not to the notice of the court.
No, petition. You just now said that first ground, right? Violation of natural justice. You have not been heard. This is passing of the order.
We have been heard. I cannot say that we have not been heard. So far as the aspects which we have wanted to.
Perhaps adequacy of hearing we cannot go into. Like we control the council on admission. Like say that don't argue, don't read statement of objects and reason. So council cannot say that I have not been heard because I have not been allowed to read statement of reasons.
A lot of peruses, page 48. There are 6.16. This is the approval given by the financial creditor after the admission of the CP. We pertinently observed herein that having been aware of the order dated 24/6/2022, whereby the petition filed under section 7 IPC by the financial creditor has been admitted, addressing the letter dated 28/6/2022 to the corporate debtor, representing by its suspended management, informing him of extension of time for payment of balance sale OTS amount is nothing but an irresponsible act on the part of the said letter. Having noticed what is being complained of, the NCLT has not exercised the jurisdiction which is vested in it under 11. This is what in the 5-member bench understood at page 185, paragraph 26.
180?
185.
Yes.
After hearing the attorney and others, the 5-member bench has passed this. In view of the law laid down by the Honorable Supreme Court, which holds that the tribunal has inherent power to recall its judgment on appropriate grounds, the 3-member bench judgment in so and so versus so and so versus so and so, observing that the tribunal does not have power to recall, cannot be approved. The 3-member bench judgments of this Honorable this tribunal, insofar as observation that this tribunal has no power to review, no exception can be taken to that part of the judgment. We, however, hold the judgment laid down that this Honorable tribunal has no power to recall the judgment, does not lay down correct law. This was not made applicable when it was brought to the notice of the NCL. And similarly, 3-member bench also at para 26 at page 111. 211, paragraph 26. In view of the law laid down by the Honorable Supreme Court, which holds that the tribunal has inherent power to recall its decision, judgment in appropriate grounds, the member bench judgment in so and so versus so and so and so and so, observing that tribunal does not have power to recall, cannot be approved. 3-member bench judgments of this court, insofar as observation that the tribunal has no power to review, no exception can be.
Merits.
And your lordships are aware, these are the agreement holders. They cannot invoke the civil court jurisdiction. And in one of the matters, the NCLT having noticed that he cannot go into it, it's the financial creditor to return the funds.
No, but we are only on the question of remedy of appeal. All of this thing without going to this thing appellate tribunal, everybody will land here as it is Environment Protection Act. Nobody goes to NGT. They file a writ petition. This thing also. Now, this is the problem, right?
Your lordships have seen any number of judgments, in your lordship's experience, that they are self-imposed restrictions.
Yes. We know that. Despite we don't want to exercise extraordinary discretionary jurisdiction.
In matters of this nature, where patent
in substance, a suit for a specific performance of contract. In substance, permit us to execute sale deed, purchase land. This is nothing. All whatever implement and all that.
That is bad.
To put it very crudely, and this is what the grievance is. Very crudely, grievances grant us as relief of specific performance of contract because we have entered into an agreement with the borrower.
Your lordship will kindly say IDC court under section 63, not the civil court jurisdiction.
No, we are not saying that you should go to civil court. We at this stage we are not examining the matter on merits. We are only relegating you to an alternative remedy under section 61.
Why I am submitting repeatedly for your lordship persuasion is, I noticed under 6.16, it's atrocious on the part of the financial creditor to approve it after the admission of C.
No, the orders are illegal. That's why a forum of appeal is provided, right, Mr.
That is it, my lord, that your lordship will appreciate that in the light of these, your lordship will consider, my lord, at least to the limited extent of considering these matters in the jurisdiction. May not be in all other matters.
Yes.
That's all.
That's all. Yes. Mark the presence, Mr. Y. Srinivas Murthy, learned senior counsel for the petitioner in this writ petition.
But in this matter, my lord, on the last occasion, your lordships have directed the district collector to file an
affidavit.
He has filed an affidavit, my lord.
So, madam, so
Yes.
tell us, where do we get it that this is antedated and all this? This is the plea which you have not taken, right, in the memo of appeal that you have considered.
We have taken it
No,
in the
last date of
memo.
hearing, we have recorded your concession.
Antedated, we had taken your lordships in
We'll
the,
admit it here, it's some other day, madam.
uh,
We will admit your appeal. We have filed an explanation.
your lordships, they have filed an explanation here, your lordships. Here, in the explanation, they have
Yeah.
stated,
What we are saying is that we are here, we will hear it on, we are admitting your appeal. It's for admission.
yes, your lordships.
How many times it has come up, madam? How
Yes.
many times? This is not the only case, right?
Yes, your lordships, but the issue remains that
I've been here for not less than 8 weeks and see our order sheets I have written. Right?
Yes.
We have heard you.
Yes,
So
your
we are
lordships.
admitting it. You have a case, but this is not the only case in the High Court, right?
Yes, your lordships.
Every time it should not be heard. in compliance of the order.
I asked one submission, your lordships. Here, your lordships, the urgency is that your lordships, the work is continuing, your lordships, and the construction is completed, the land is plotted, your lordships, and our land, somebody else has been paid and we have not been paid compensation yet, your lordships. Hence the urgency, your lordships. Your lordships may admit it.
All right, argue right now. We have the order ready. We have to only add 3 paragraphs. We have heard you such detail that everything is ready, huh?
Yes.
Why it should be this thing?
Your lordship,
Why the order passed by learned single judge should needs interference? Please tell us.
your lordships, we have questioned the learned single judge's order only partially, your lordships, because the learned single judge accepts the fact that the compensation has been wrongly given, your lordships. However, because the compensation has been given, the learned single judge has stated that the compensation has to be recovered from the people to whom it has been wrongly given.
Yes.
And given to us, your lordships. The only point is that, your lordships, the gazette, your lordships, the preliminary notification has to go.
Submission.
Your lordships, the first submission is that, your lordships.
Preliminary notification dated 11/1 should be quashed.
Yes,
Why?
your lordships. Your lordships, the preliminary notification, your lordships.
Why it should be quashed?
After the extension of the same, your lordships, I have filed a memo, your lordships. A memo recently, your lordships, on 29/8/23 for your lordships review. In the memo, your lordships, I have given a chronology of dates.
Why it should be quashed? Madam?
Your lordships, the reason it should be, I have given a chronology of dates as well as the.
Last date of hearing, we have made 3 submissions which we have recorded.
Yes, your lordship.
First is that preliminary notification names of third parties have been mentioned. Objection preferred has not been decided expeditiously.
Yes.
Till today, despite no consent award has been passed, neither any consent award, nor general award. And this thing, the preliminary notification was issued on 30th January 21. And the period for conducting further proceeding was extended on 18/1/2022 by district collector.
Yes.
The extension has been antedated and uploaded in the month of May 22.
Yes.
And not mandated. And then this thing you have said, Gazette, this thing, these are submissions.
Yes, yes, your lordship.
Yes, Mr. Anything else?
Only one consideration is that, your lordships, the gazette that is antedated, your lordships, it has not been gazetted in accordance with 3V of the Act, your lordships. I will take your lordships immediately to the response that they filed, your lordships.
No, what happened to the learned single judge WP 6347? Same gazette notification is pending adjudication before single judge, and you are here, you are telling us that urgency in the matter.
Which?
WP 6347.
That is the different, your lordships, where a slew of gazette notifications, your lordships, not this one, have been challenged, your lordships, on the fact that they were antedated and not properly gazetted, your lordships, in accordance with the law, and the honorable single judge was pleased to stay for the proceedings in those notifications, your lordships, and he had also called for the records, including note files of the said notifications and antedated extensions, your lordships.
Madam, so what ground you are challenging order passed by? This is a writ appeal.
Yes, your lordships.
Yes.
Your lordships, their affidavit, your lordships, in their affidavit that was filed pursuant to your lordships orders, your lordships.
No, you are saying that the notification under 11/1 should have been quashed,
Yes,
right?
your lordships.
Why?
Yes, your lordships. The reason it should be quashed, your
We
lordships.
have told you just now.
Yes, your lordships.
1, 2, 3, 4, 5. We told you.
Gazette notification, your lordships, the antedated, I have shown your lordships. I'll take your lordships once again. Fact that it was antedated is on page 5, 10, your lordships, of the writ documents, your lordships. On 510, your lordships would see the antedated upload, your lordships. 510.
510.
510, your lordships. I will not take your lordships time. I will take your lordships to
510.
exactly the same.
Which page? 510.
310. Five pen your lordships have. Your lordships would see the upload of the said alleged extension, your lordships. that it was 28/1/2022 and the upload is on top, your lordships. It was in the fifth month, your lordships, 5th of 2022, 5th May of 2022.
And for the appellant, your lordship.
Then your lordships would kindly turn to page 761, your lordships. 761. First point that it was antedated. Second point, 761, your lordships.
Respondent, your lordship.
In the same material documents.
Your voice is not.
Your lordships, 761 is how a Telangana Gazette is, your lordships.
Yes, your lordship.
And 762 is the Gazette that they passed, your lordships.
Has been filed by the respondent.
762.
For the appellant.
Can you order
With the Gazette number
question we are asking you?
41 of 2022. Your lordships may turn it and see that it is published by, not in the Telangana Gazette, but if your lordships would see on 763, beneath, it is published by the district collector of Siddipet in Karimnagar, your lordships.
Submitted, no? If you don't bring the LRs.
Format is Telangana Gazette, your lordships.
Has to be ordered, I think. Am I right?
Now your lordships,
Otherwise,
your lordships may juxtapose it. I have filed a memo on 29/8/23, your lordships, with SR number.
Yes, sir.
83708. 83708 SR number memo.
Senior, your lordship, kindly it may be posted after 2 weeks.
LR has to be ordered.
Just
Then only you can
2
pursue
more
the
pages,
state
your
action, the
lordships,
first
and
appeal. Otherwise, first appeal has to be closed as abated.
the
You'll
your
not get
lordships
any
have the
relief.
memo, your lordships.
Who is your
The
senior?
memo I filed on
Ravindrababu, your lordship.
29/8/23.
Ravindrababu.
29/8/23.
Is out of station.
Your lordship.
28/8.
28/8/23.
Yeah.
Yes, your lordships. In this, I've also filed a chronology as your lordships had requested. I will quickly take your lordships to page 17 and 19, your lordships.
Chronology.
Chronology of dates. Your lordships had earlier requested a chronology of dates. I've included that in this
Where?
memo on page 2. Page 2. Page 2 is a chronology of events, your lordships. Now I will take your lordships through the specific gazette, your lordships. 17 and
It
19.
was listed only on
Your lordships,
10/9/2023.
on page 17
And you are saying
is the same Telangana Gazette that the respondents had produced, 41 of 2022, dated allegedly 28/1/2022.
First appeal
And your lordships, it's printed in the district of Karimnagar, your lordships. It's not the Telangana Gazette. Now your lordships, on
That
page.
you have already told us.
Yes, on page 19, your lordships would see the real Telangana Gazette, Gazette number 41.
Will be there. If the
Page 19, the real Telangana Gazette, Gazette number 41, with the price denomination and printed. Where Telangana Gazettes are printed.
No, you no 1 minute.
Government Central Press, Chanchalguda, Hyderabad.
First appeal stands
At
abated.
Government Central Press, Chanchalguda, Hyderabad.
First appeal stands
The
abated.
said Gazette number 41 has nothing to do with the alleged 41 on page 17.
What?
On page 17, on page 17 is the gazette that the respondents had produced vis-a-vis this notification, which is manufactured, your lordships. And on page 19 is the real Telangana Gazette number 41 that has been printed at the only place in Telangana that is authorized to print the Telangana Gazette in Chanchalguda, Hyderabad.
Independent suit. Independent appeal. It's not dependent on the appeal filed by them.
A junior member of your bar is asking time when you are published.
In the affidavit, they say Siddipet Gazette, your
Let
lord.
it be 10 years.
Got it.
also.
Yes, your lordship.
In sum and substance is that
When both
this
sides are ready,
district
they will
collector has no
nominate.
authority to
1
publish
minute.
like.
No, your lordships. In
When both sides
the
are ready, they
affidavit,
will
they
nominate.
claim that The district collector is the appropriate government to authorized to undertake decisions under this act. But the affidavit, in the affidavit that they filed before your lordships,
In any other case of a land acquisition where it has been published in the gazette like this, page 19, you.
yes, your lordships, your lordships,
from a senior.
they have not published in the gazette so far, your lordships. That is the reason this honorable court itself.
No, madam, in any other case of land acquisition, they may have done so, like page 19. In any other case.
Yes, they must have, your lordships.
So get it one, for instance, like, this is something Constitution of Agriculture Market Committee.
Yes, your lordships, I have filed IA3 in which I have given interim orders
We have understood, right? Like, I mean, the same gazette, 40 number and 41, and what you want to submit is district collector has no authority to print this gazette.
Yes, your lordships. The district collector does not have the authority to print in the district gazette, your lordships, and he does not have the and in the affidavit that the respondents have filed, they have stated that for the first time that it is in the district gazette. However, when they have submitted the same said government in front of the learned single judge, the learned single judge they have clearly stated that it is in the Telangana gazette, which means that even the learned single judge has been misled as far as the Telangana gazette is concerned. If I'll take your lordships in the page 40, if your lordships, page 40 of the page 40 has the learned single judge's order, your lordships,
All right.
of the writ appeal material documents.
What else, madam? What else? They owe an explanation. Yes, what else?
Everything is
This is the specific contention, your lordships. Even the PN has not been extended. The alleged extension is antedated and it has not been gazetted in accordance with section 3B as required under the Land Acquisition Act. The other aspect is that, your lordships,
Gazetted under section
3B,
1 minute.
3B, B as in victory, your lordships, victory, 3B. And of the memo, your lordships, and on page 5 of the memo, of the same memo, I've included all the gazette numbers, your lordships.
Act, 2013 Act.
2013. 3B.
Docket बताना मैं.
The reason why we went and asked, it should be the next time.
How many times this case was listed before this court? Then you are saying that from 1 year we are adjourning the case and all those things. Please tell us, no?
You can extend within time.
How many times this case was listed before this bench? Please answer that, counsel. We have no other.
It is in 20. It is in 22. It came before the earlier division bench. It is first time. So that's the reason we asked her.
She said this not gazetted under 3.5 and collector is no power.
1 minute, senior counsel.
So two submissions, madam, as we have understood is that
not like that.
it has not been gazetted under
1
section
minute.
3.5 and second is
Cannot
collector
agree.
has no
Just
power,
for-
3V
Yes.
and collector has no power to this thing.
Your lordships, yes, your lordships, the collector as the appropriate authority would have the power, but 3B is very specific and categoric in its, in the manner in which it is read, if I may read, your lordship.
Then, so what is the third submission? First, you must tell us these are the submission, then elaborate.
My first submission is, that, your lordships, it's antedated. It's antedated and not in accordance with 1907, your lordships. 1907. It's not in accordance with 1907 or proviso. Your lordships had heard me before on this.
High regard for you. 1 minute. 1 minute, sir. Even when we are
19, it's antedated and not in accordance with third proviso. Then the alleged extension is not in accordance with section 3V. V as in victory, not Roman numeral V, your lordships. V as in victory, small v. The third aspect is that, your lordships, on page 5 of the memo, I have given a table of the dates, your lordships, of all the dates of the memos, of the gazette numbers, in which your lordships would see on page 5 of the memo that your lordships have, after the synopsis.
We will argue on the.
I have given all the gazette
To
numbers.
conclude, madam, I would like this thing, we are,
No, your
we
lordship.
don't want to hear it, then otherwise we will admit if you want to argue then.
There is one submission, your lordships. The gazette numbers, they do not match with the months, your lordships. Hence, they are not in keeping with the Telangana requirements, your lordships, and they are antedated. It's an example of the same, your lordships. Gazette numbers from page, from item number 46.
Number 41 is your case, right?
Yes, yes, your lordships. And then on page 6, your lordships would see item number 19, 18 and 17 at the end.
Item,
January, your lordships, if your lordships would see the date of the proceedings. January is on page 5, 8, 2022, 1, 2022, and then 41, your lordships, 41 and 40, 28, 1, 2022. They are odd men out, your lordships. They are not in keeping with the manner in which it should be.
which page 5, right?
Page 5, your lordship. Page 5, January 4, 2022. To show your lordships that they are not in keeping the seriatim, your lordships. 1, 2022, 12, 1, 2022. Then suddenly, if your lordships would see 41 of 2022, on 28, 1, 2022, and 40 on 28, 1, 2022. And then again, they go back to page 6. 7 of 2022, again it's 15 to 2022, and then once again they come back to 33 at the bottom, your lordships, 20, 19, 18, 17, 33, 2022 dated 34, 2022, 38, 2022 dated 2, 5, 2022, 39, 2020. At the bottom, your lordships, not in seriatim, showing that they were manufactured, your lordships, and clearly antedated. The other aspect is that, your lordships, yes, I've made the antedated averment in the main writ affidavit as well as in the synopsis also, your lordships.
Writ petition, where which paragraph you pleaded in the writ petition?
Your lordships, additional affidavit on page 5, your lordships.
Writ petition, madam, this is all improvisation. Writ petition, did you implead that it was antedated?
Your lordships, not in the writ appeal. In the writ appeal, I've
Writ petition, you have not implemented.
we got this information after the fact, your lordships. Writ petition IA 7 is additional grounds. We have about the same, your lordships. Writ petition.
But this project has been implemented, right? Your land has been utilized, correct?
Is being utilized as we speak. The construction, the land has been cleared and plotted for construction. That is the present situation
Construction
right
of
now.
what? Construction of
Construction of allegedly rehabilitation colony, resettlement, rehabilitation and resettlement colony. I have made this averment, your lordships, in IA number 7 of the writ petition, your lordships. Okay. Yes, yes. Here, if I may state.
That's it?
Yes. Here, if I may state so, your lordships, the Honorable Single Judge has stated that they have wrongly compensated the wrong party. He has only stopped short of quashing the preliminary notification, your lordships, because he was given this Telangana Gazette, this alleged Telangana Gazette at the last moment, and on page 40 he records the same, that a Telangana Gazette extraordinary published with number 41 of 2022 dated 28/1/2022 has been given to him just now. On page 40, the first paragraph, he records it, your lordships. He goes on to state, that it is.
We'll hear you, madam, some other time. It will need some time.
Only
Or on the question of admission, appeal is admitted for hearing. Yes.
Your lordships, just one more point, your lordships.
No, it should not be like that. We are trying to asking you to hurry up. You argue at your own, it will be heard. File an application for urgent hearing, it will be heard.
Your lordships, those were the
Appeal
only
is admitted
points
for
I
hearing.
was, wanted to clarify before your lordship.
Please argue at length. Mister, you have understood, right?
Yes, yes.
Explain what is it?
Yes, yes.
Which provision district collector has power? What is the discrepancy?
Yes, I have noted down. Right? In fact,
please explain.
Yes.
Admitted for hearing.
Your lordships may hear it finally
No.
at some point in time, your lordships, because
Please move an application for early hearing. We will consider, madam. Yes.
those were the only 2 points that I wanted to submit, your lordships.
Repeatedly, we were asking you to conclude. We thought that it can be done, but we don't want to this thing.
Your lordship,
You don't, I mean, we don't want to pressurize you to conclude in a minute.
that
You
was
will
the
argue
only
at a
point.
hearing.
Lordships had heard me and
Yes, next month.
had, your lordships may give a specific date, your lordships.
No date. While admitting, we don't give a date. Please make an application for urgent hearing. Yes, please.
But the appeal is filed, my lord, the writ appeal against the orders of the learned single judge. That the learned single judge directed, my lord, while setting aside the orders passed by the statutory authorities, avail the civil remedies. Against which, my lord, I filed this writ appeal. But the facts are like this. The appellants filed a statutory appeal under section 5A of the APRO Act.
No, but you have filed the suit and
I have not filed, my lord. They filed a suit. My lord, first I filed an appeal against the issuance of the Patadar passbooks. It was allowed, my lord, on
You have not filed the suit.
Yes, my lord. I have not filed the suit. My lord, my appeal is allowed. Subsequent to the appeal, allowing the appeal, they filed a suit. And simultaneously, they availed the remedy of revision.
No, but see what these are. I want to understand for myself. These are the entries made in the revenue records, right? How does it confer title on anybody?
Revenue entries
They are all subject to result of the writ petition to the civil suit, which is pending 5 to 7.
That is 2012 suit. My lord, subsequent to the allowing of the appeal, they filed a suit. It is not that before or subsequent during the pendency. My appeal is allowed on 18th February 2012. They filed a suit in the month of October 2012. 8 months following the appeal. And simultaneously.
No. See what happens if the order, the revenue records stands in your name. What happens? You are the owner.
I'm the owner, blood. Their names were continued.
Ownership will be decided in a civil suit once it is
not ownership do not sought. They simultaneously sought only corrections of the same under section 8.
What is the suit then they have sought?
Suit page 64, your lordship, my kind is the
What is the suit for? You are here to assist us.
Suit is filed.
Permanent injunction.
Yes, my lord. Property in respect under section 8 of the Act, 8 of the Act, questioning the entries. Is not, they are not seeking title, my lord. They are only questioned the entries.
What to do, admit?
That was dismissed for default, my lord. 21/11/2017.
No, he says suit is filed after February, October 10, 8 months. All right, appeal is admitted for hearing. Yes. Appealed on IA 1 of 23 issue notice
for the
of IA 1.
May I please?
Yes. Yes, please.
This writ appeal is not filed against the orders passed by the learned single judge Malad in writ petition number 7317 of 2013, wherein the writ petition filed by the Malad petitioners are dismissed. But on the ground that Malad, the representation was Malad filed by the unofficial respondent, but was treated as Malad as an appeal. And Malad, the orders were passed by the Malad, the third respondent, which was not confirmed in the writ petition. But initially, Malad, the ROR proceedings were issued in favor of Malad, the appellants, Malad, in 2005.
This is only an order of remand by the revenue divisional officer, which has been upheld by the learned single judge.
In the other Malad writ petition, it was remand, but Malad, two writ petitions were filed. One is Malad is WP 7317 of 2013.
That has been dismissed by this court.
No, the other writ petition, writ appeal which was filed against the orders.
880, Mr. It has been, writ appeal is dismissed.
Writ appeal, Malad, 880 of 2020 was dismissed. Malad, which was filed against the orders passed in Malad, WP number 14001 of 2008.
That we know, Mr. We are telling you, come to the merits of this case, why we should interfere with an order of remand and
on three
can't declare you owner in a writ petition.
Yes, on three grounds, I filed the appeal before the Supreme Court. Even I have raised the said grounds also in the petition. One is with regard to one is the appeal is filed by the unofficial respond number 4. 7 years of granting ROR proceedings in my favor.
So the order of remand, all of whatever you are arguing, you can argue before the appellate authority or whatever authority to whom it has been remitted.
My submissions before Lordship is 7317 2013 is dismissed. Against dismissal of that, I filed the present.
We know that.
Yes.
What grounds you are challenging the order of dismissal?
I filed this appeal on three grounds. One is the fourth respondent has not filed the appeal within the stipulated period of 30 days as per section 5B of the ROR Act.
So therefore, it cannot be remanded.
Therefore, it cannot be remanded and it cannot be treated as an appeal. And if the fourth respondent has got any grievance,
we can raise all objections. You can raise all these objections that it is barred by limitation, everything before the authority.
But I have raised
there
this
is no adjudication right.
I have raised on this ground in the writ petition also, but the learned judge, single judge has not considered that aspect. Only stated that the representation was filed by the unofficial respondent treated as an appeal under section 5B of the Act. Para 15 of the judgment. But the other ground on which I filed the appeal is that notices were not served on the petition on the appellants, but while passing the orders by the appellate authority, third respondent. But last can you see the appellate
all claims you can raise before this thing, right?
On page 34, they say
before Tehsildar, ground whatever, which you are arguing here, is it not?
But when I have raised all these grounds in the writ petition, those grounds were not considered by the learned single judgment. Though in earlier the another learned single judgment clearly held that when the appeal is not filed in the prescribed pro forma, it cannot be entertained. And the writ petitions were allowed in my earlier occasion. But writ petition, the order of that learning signature also became final. But I have got that also this year's the judgment of learning signature were also not considered on this aspect. Though it is the order of learning signature on the point of appeal, but this became final
who has not taken into account another learned single judge.
Yes.
The single judge who passed the order in your case.
Yes.
All right. What else? Third point.
But the other is when the issue raised by the fourth respondent is touching the dispute related to the title dispute, it can't be entertained in an appeal filed before the authority. And the same can be resolved by the competent civil court.
All the contention, we will say, all the judgment of it. Right? It will be seen, what it is saying. Yes.
In the summary proceedings, that title dispute cannot be decided. That is what my submission.
That's it.
Yes.
This intra-court appeal, yes, madam. This intra-court appeal is filed against him.
Yes, okay. May may permitted to mix my submission, Your Lordship. Virtual. I am for the petitioner in 19th item, Your Lordship. Only permit me to make my submissions virtually. Yes, Your Lordship. The petitioner before Your Lordship is auction purchaser of the property. It is now again being auctioned. It was auctioned, and I'm challenging that.
No, auction has been held on 30th August.
Yes, Your Lordship. Auction, I find, but because there's a technical problem with that, I can complain. It was a bit delayed. Your Lordship. Your Lordship, the petitioner before Your Lordship purchased the property in auction held on 23rd March 2018. Your Lordship.
His appeal is pending before DRHC. Why he can't file that application?
He filed an application before Your Lordship. I filed an application before DRAT, Your Lordship. That was
What
not
happened?
taken. Kindly have a look at page number 17, Your Lordship. Kindly have a look at page number 17.
17.
17. This is the.
What happened, mister? Will you not tell us that?
Your Lordship, I filed an application for stay of auction proceeding before DRAT, Your Lordship. I filed an application.
Auction has been held on 30th August or not?
Yes, Your Lordship.
Then-
It may be confirmed not to, at least if the proceedings, if it is stayed now, auction will not be confirmed, so that my interest will be protected. That is my simple submission, Your Lordship. Here, I filed an application, but
His application.
was taken by in a writ petition before Your Lordship.
Counsel, what happened to your application pending before the appellate authorities?
Still it is pending, Your Lordship.
But already the auction has been completed on 38 2023.
That was my submission, Your Lordship, without hearing me. It was posted to 27th September before DRAT on the ground that limitation application, condonation of delay application is pending. The delay occurred due to filing I filed a writ petition before Your Lordship earlier. The time taken for the writ petition was considered as a delay.
That's what he's saying, that direction to this thing. No, he's saying that.
Submission chronological things, Your Lordship.
Say if not already confirmed, the prayer is grievance is confined to only. And so ask him when did he file the application before DRAT. When did you file your application before DRT?
On 3rd March 2020. 23rd March 2022, Your Lordship. That was not taken on record for want of delay confirmation, Your Lordship.
Till today.
Till today, it is
it's under pending, no?
delay, Your Lordship. I filed a writ petition prior to against the impugned order, original impugned order, Your Lordship. The writ petition was disposed.
Right. So listen, yes, mark the presence. The grievance of the grievance of the petitioner in this writ petition, who is an auction purchaser, is that even though he had filed an application before the debt recovery appellate tribunal on 23rd March 2022, yet they say seeking stay of
the proceedings which were initiated on 30th August 2023, Your Lordship. The same property which was purchased by me in 2018. That
so your application is 23/3, much prior to the auction date.
My appeal, yes, Your
Seek auction.
my appeal before
See, don't, he is unable to tell you, right? Grievance of the petitioner in this petition is that his interlocutory applications are pending consideration before debt recovery appellate tribunal. In view of aforesaid submission, issue notice, personal notice, proof of service. Yes.
not to confirm the auction, Your Lordship.
Nothing.
Otherwise, it is.
Let it be confirmed, nothing happens. You don't know what date you have filed the application. You are telling us a date prior to auction. What can be done? Yes. Next.
My application before
Next.
Your Lordship, I'm ready. I'm here to assist the court in all chronological events, Your Lordship. I'm not able to get what is the question actually.
May I please your lordships, I have filed by IA number 3 of 2023, my lord. Serious incidents have been taken in the across the state. Those SC, ST, BC girls
IA3.
have been studying in the.
1 minute, don't. We are hearing you. Don't. What happened? They are here not to contest the petition. It's a public interest litigation.
Yes.
It should be IA. Everything should be decided in a cordial atmosphere,
Yes.
right?
Yes.
We are willing to what, but don't get agitated.
Yes.
What happened? This is, we have 1 minute. We have issued notice on 11th of August 23.
Yes.
You, in this petition, you had said that for providing bathroom and toilet facilities to the inmates in the hostel in educational institution in state of Telangana.
Yes.
Now, what is IA?
IA, my lord, to complaints report of the mandate provisions which have been enacted by the parliament, my lord, my prayer is categorically stated at page 14 of the IA, my lord.
Compliance report, sir. No, what is the prayer?
Prayer, my lord.
Tell us, no, mister. You tell us what is the prayer. See, Mr. Prabhakar, the difficulty is that the prayer runs into one page. It is virtually impossible. You would do well to break it up 1, 2, 3, 4, something like that. Following prayer 1, 2, 3, 4. It will be easy for us to read. This prayer itself runs in one page.
Yes.
Difficult to understand. I mean, I really, I'm unable to make it. What is this?
Off page itself has been stated clearly, my lord. They are not providing a proper food and not maintaining the hygienic conditions of the kitchen and not maintaining the hygienic conditions of the bathrooms and latrines and the atmosphere of the hostels, so that many girls are being taken place.
Oh, let's submit compliance report.
Chapter 4 guidelines, Miller, categorically stated in by
Chapter 4, what? What are the guidelines?
in
Where are?
writ petition I have stated in at page 126 and 130, Miller.
Yes, Mr. What do you say? What is, we don't know what is chapter 4 of guidelines of National Commission.
At page 126, Miller, of my regulation.
Norms and standards.
Norms and standards.
What do you say? They are asking you to submit a compliance report. Basically, it means to provide better infrastructure facilities to inmates of the hostel in educational institution. You file the status report.
Yes, ma'am.
Status report so far responses are concerned I filed.
See this.
Counter also file.
After they filing the counter, Millard, series of incidents have been taken and many girls are being suffered from the food poison and heavy fever and headache, stomach ache, and the same reports are being enclosed before your lordship.
Main rate is so main rate is some other prayer, IA is some other prayer, Mr. Prabhakar.
After series incidents have made this one.
All right.
File a report, Millard.
File a status. Third Learned Council for the parties on IA 3 of 23.
Yes.
How much time? 2 weeks.
Like 2 weeks.
Learn it so and so. of pleading do not apply. Rules that you should prepare the case also does not apply. Anything free for all. Yes, next.
Biblioplex.
Yes. 21.
And this matter, I'm like to apply Mirat today. Earlier, additionally, you appear Mirat, I'll prepare the matter Mirat 2 weeks after.
Yes.
On this matter, Mirat pertains to Mirat the eviction, Mirat public.
Yes.
I filed a vacate in this matter, Your Lordship.
You have filed vacating.
Coming up for that.
He is praying for time. Learned Mr. Praveen Kumar Learned Ji is so and so praise fund is granted 2 weeks time to enable him to seek instructions and to argue on IA 1 of 23. Right. Yes.
IA 1 of 2023, appeal.
Yes.
579.
Yes.
The Lords kindly admitted the writ appeal on 29th August.
Yes.
Okay, this is against the recovery notice is now issued.
Recovery notice for what?
Under FEMA. Challenging under FEMA.
We are ready to decide this, Mr. We will hear you.
After lunch. So because
After lunch or some, he is there in a parted matter. Some tomorrow, if you want, tomorrow we can hear you.
Yes.
Let the appeal be listed for consideration on Saturday, 23/9.
not
23/9.
it's an emergency because
Tomorrow itself. We will get ready on merits. We will decide on merits itself. Tomorrow is what? All right. Tomorrow, day after.
ask me not please.
21st September. Yes. Next. Yes.
That's all these.
All right, these matters have been admitted, stay has been granted.
Yes, Milord.
Yes. Why it is listed?
That's no letter.
We don't know. All right, the appeals have already been stated. Appeals have already been admitted for hearing and an interim order has been granted. That let the same be. '26. Yes. Yes, counter.
Let's counter file me. Let's
file.
Relax.
So why it is listed today? There is a challenge to validity of the provision, right? You are appealing for respondents.
That's the only thing is like Millard's only for particular.
Learned counsel for respond. You don't want to file any reply?
Yes, Millard's.
All right. Counter on behalf of. Submits 28 that the appeal has been rendered infructuous on account of reflux of type. The aforesaid submission is placed on record. The appeal accordingly, the appeal is dismissed as infructuous. Yes.
27th, I'm ready. I'm ready, Milord. 27th, I'm ready.
You are appealing for respondents.
27th, Milord.
What? Yes, Mr. Vaidyanathan. Which case?
64, 65.
64. We'll take it up after the break.
Yes. Great. Great.
And it's putting up.
My lord, this writ petition, my lord, is filed, my lord, questioning the respondent number 2, my lord, in not permitting the petitioner, my lord, to participate in the counseling in MBBS course, my lord, for the year, this academic year. My lord, three facts are like this, my lord. On 7/7/2023, my lord, petitioner has applied, my lord, for competent authority, my lord, under competent quota, my lord, that is for paying requisite fee and submitting all the requisite documents, my lord. My lord, on 7/7, my lord, 2023, my lord, the A category, my lord, the A results were announced, my lord, and were given, my lord, 469 category, my lord, seat, my lord, as economically a weaker section, my lord. My lord, second round and third round was delayed, my lord.
Why they are not permitting you to?
Yes, my lord, I'm coming to that point, my lord. Second round and third
This
round.
thing,
Because, my lord,
C is management quota, C is NRI.
yes,
Please,
my lord.
NR.
Management and NRI quota.
NRI.
Why you are not being considered?
My lord, at the time of first round quota, my lord, simultaneously, my lord, B category notification also, my lord, issued, my lord. I was issued, my lord, on that ground.
First round of counseling held between Mr. Rao.
First round was
No, first round was below the one. I just. Second round is also completed, Lord. By today,
As-
Why you are not permitting?
Lord, she was allotted seat, Lord, in the first round of counseling, Lord, in Kamineni Medical College. Lord, she was supposed to report, Lord, on 2/9/2023, but she did not report.
Oh, so that rule.
Lord, it's there, Lord, she filed copy.
The rule has been filed. Which page?
Lord, page 22, Lord.
20. No, that rule, which requires.
Rule
that if you are told, no, we had.
GOMS 126, Lord.
Where is it?
I do not have the copy.
120. That rule we have quoted, right?
Madam.
Where a candidate is allotted a seat.
And failed to join course. Failed to join the course is not eligible.
Yes.
For further round of counseling.
My submission, my lord.
Madam,
My lord,
first round, 1 minute. First round of counseling, you are allotted seat.
yes, my lord, I will come.
Huh?
Yes, my lord.
First round of counseling, you are allotted a seat.
Not first round, my lord. It's, my lord, simultaneously, my lord, I was applied, my lord, under B category. B category, my lord, I was under hope and, my lord, after
You
completion.
can't say yes when the court
I
says
was great
something.
impression, my lord. I was great under great hope, my lord. I thought that I may get in A category seat. But, my lord, unfortunately, my lord, I didn't get that seat, my lord, in first category, A category. Later on, my lord, B category.
You are allotted a seat, right?
Simultaneously, my lord.
Which round of counseling, according to you, you are allotted a seat?
According to my lord, I was under hope, my lord, that I may get in B category.
Madam, first round of counseling, you are allotted a seat. Is this statement correct or not?
No, my lord, it's not correct.
B category, B category.
I was not in.
Mr. Rao, she feels that she has not been allotted a seat. And madam, if your statement is found to be false,
yes,
he will go to jail.
No, my lord, I was under impression.
No, that's,
my lord,
madam, this is very factually making incorrect submissions. We take it very seriously. Very seriously.
Yes.
I mean, but you can argue that this rule doesn't apply, this is bad, whatever. But factually making incorrect submission, he will, instead of getting a seat in admission, he will land up in jail, right?
Yes.
He will record your submission.
My lord, one submission.
Mr. File.
My lord, let me finish my arguments. My lord, page number 13, my lord, para 9, I have stated, my lord.
First submission,
Category.
1 minute. First submission is that petitioner has not been allotted a seat.
Petitioner was allotted, my lord, seat in Kamini Hospital, but after, my lord, I was under great impression that I may get seat in 3 rounds.
We asked you whether he was allotted.
3.
Either you don't understand or you're too smart. These are the two only inescapable conclusions.
You can understand.
You can understand, right?
Yes.
First round of, if in previous round of counseling you have been allotted a seat, then there is a rule which debars you from this thing. You, in the absence of any challenge to the validity of the rule, we cannot do anything. This petition is a foregone conclusion, right?
Because, my lord, I have waited
You have been allotted
3.
a seat in this thing, no, previous round of counseling.
Yes, my lord. Because, my lord, I was waited, my lord, 3 rounds, my lord, I could not get the seat in
Congratulations for getting a UG seat in TSMQ first round of counseling. Despite that, madam, page 22, your own document, you are making a statement which is factually incorrect. Page 22. What is this?
This combination, my lord, they were, my lord, on,
No, this says first round of counseling, you have been allotted a seat.
yes.
And you are saying I have not been allotted a seat.
My lord, they were, my lord,
This,
they were-
you have to be, you are an officer of the court, madam.
yes, my lord.
You have to be fair to the court. Don't
Because,
make
my lord,
incorrect factual submissions.
One submission, but I was under impression that I may get, great, my lord, I
Anybody impression?
get, my lord.
Your impression, thankfully, that you will become president of India. What can we
I
do?
waited, my lord, 3 completion of 3 rounds, I have waited, but they have not denied.
This rule is there, no? That which this entitles GOMS 125.
126 lots, 126.
126. You have it.
My lord,
Yes.
latest, my lord, 14/9, my lord, when I approached the authority, my lord, they said, my lord, I am not entitled. Because, my lord, already when I have submitted it through online, my lord, on B category quota. And my name was reflecting that already my name was registered, earlier it was open. I was
That's
under
it.
impression.
Anything
that-
else? Anything else, madam?
My lord, Honorable Supreme Court, my lord, has stated, my lord, categorically, my lord, again and expressed, my lord, that students who are merit students and that should not be on even technical issues and merit students, my lord, that students may not be deprived, my lord, their rights. That's the reason, humble request, my lord. And moreover, my lord, 3 rounds I have waited, my lord, under great hope. That's the reason, my lord.
Everybody has a hope.
Second time when I approached authority, they were denied. I
Okay.
am not entitled. Your lordships may kindly consider on sympathy student life, my lord, your lordships. Honorable Supreme Court, my lord, has categorically stated merit students should not be should not be deprived. On merit quota.
No, this is it. We have quoted GOMS, some case where condition that if a candidate is allotted, he is subsequently, there is a rule, Mr. You should have got it.
114 also there, but I don't know that she moved a lunch motion, I could not get.
Oh.
Because, my lord, today.
There is a rule, madam, which debars you.
Waiver options, my lord, today were issued, my lord. Your lordships may kindly consider and direct the authorities, my lord, to consider my request.
No,
to
you are telling
appear.
this court to grant a relief contrary to statutory rules, which is not permissible. Yes. Anything else, madam?
My lord, Honorable Supreme Court, my lord, has again, time and again, my lord, stated that merit students' rights should not be discarded. My lord says those who are merit
It's
students.
unfortunate, madam, that you are not even aware about the rules. You are not. There is a provision in the rule which disentitles you to participate in the further round of counseling if you have been allotted a seat in first round and have not taken admission.
Delay caused in, my lord, 3 rounds,
Yeah,
my
we
lord,
don't
and these honorable court directions, my lord, they have opened late, my lord. That's the reason, my lord, I could not join in that college.
Whatever is the reason, the rule is against you. We cannot grant any relief
I may get-
under Article 226 to
Under
contrary
big
to
category,
relief.
my lord, this was.
Which is
my lord, your lordships may kindly grant a last chance, my lord, I may get that opportunity of appearing my counsel. Let me try
Which is
my
the
luck.
rule,
My
Mr.
title.
Law. Roman 4. Test. Let's see. Not like they are we not
Have to go.
unsaid.
If I'm entitled, my lord, as a last chance, your lordships, my kindly grant student, my lord, merit student, only 1 mark difference, my lord, under A category, third round got, my lord, seat.
Fine. Heard on the question of admission, petitioner is an aspirant seeking peace.
May I please proceed?
Yes.
My lords, this court has already decided on the NCC issue, but my facts are little
This is right. This interim order has already been passed. Why have you got it listed?
My lords, we have moved an urgency
Early date.
because today is the last date for the admissions, my lords. And if this petition has not been decided, the entire writ petition will become.
No, Mr. Don't stop making a lunch motion for early hearing date. We were given an impression in the mentioning stage you had not appeared, right? Somebody else had appeared and
my colleague has
colleague said that the matter pertains to medical admission. He did not say writ petition has been admitted, interim order granted, and you have filed. You want an order on fixing an early date of hearing. This is Mr. This is unfair to the court. The matter has come up on IA 4 of 23, fixing a date of hearing. How can you, see, that means you are telling us that please do not rely on us because we are capable of making false statement and misleading the court. So therefore, do not believe on us.
No, my lord.
And this is what it is. Did he ask him, did he tell that my brother is also here? Did he tell that it has been admitted, interim order has been granted? What he said is a admission matter relating to admission, medical, and thereupon we granted.
My apologies on behalf of my.
No. Have you filed any application? It's not listed. It's only for IA 4 of 23.
IA 4 is for the urgent listing of my lords.
That is the only IA which is listed. According to the office, this is the only pending IA. You are seeking, ask yourself this question, is it fair on your part to get a lunch motion for deciding an application for early hearing? Ask yourself, you will get the answer.
I apologize, my lords.
No apology, mister. Why? But you ask yourself, is it fair on your part? Ask yourself, you will get the answer. There is already an interim order. Any subject allotment of seats shall be subject to outcome of the petition.
My lord, there is an interim.
If the provision for horizontal reservation is struck down, we will see what can be done. You don't doubt the powers of this court to create direct creation of a seat for you, right? When in the event of your success.
No, my lords, what we are seeking is only to continuation of the previous policy. We are not seeking any.
How can we direct continuation, Mr. This is only misconceived. You cannot argue the petition in the garb of early hearing. That's what exactly you are trying to do, Mr.
I apologize.
Please.
I do not.
The rate petition has already been admitted for hearing. Learn it, Mr. Rao. Ask your colleague to be more this thing, right? He should have said that I want orders on IA for early hearing today itself. Then we would have dealt with different.
I apologize for.
No apology, mister. Tell him.
Yes.
Because he will have now henceforth, if he appears, we are likely not to grant him because he is capable of misleading the court, right?
I apologize and I.
No, there's no question. Tell him.
Train him proper.
Yes, that's what. Yes. Yes. Wait. The notes, no. Notes. 19th September. Yes, Mr.
Wait. I have placed the relevant documents, only one or two documents remain, I just want to place it. I have placed the note 5, notings 5, and up to the date of issuance of the impugned order. After the issuance of the impugned order, at page 181 is the letter from Chief Secretary to the Secretary Ministry of Power. Page 181.
Three seven triple five, right?
That's
181 in 37555.
yes, that's right. No, 37599. 37599.
37599. Oh, yes.
599.
Yes. Page
181. Yes, this communication dated 11/9/2022, and in the reference, Government of India's impugned order dated 29/8/22 is referred to as serial number 5. And it's mentioned Government of India has issued certain direction. And we are pointing out that certain amendments, certain statements made in the impugned order are incorrect. The government of Andhra Pradesh, Andhra Pradesh has unilaterally cancelled all the PPAs. State of Telangana approached APERC and SRLDSC against cancellation. APRC, by the reference, third citer has directed that the attempted withdrawal of select PPAs is not valid. I'll place the order of the APRC also. And as such, PPAs cannot be unilaterally rescinded by AP Genco. It is pertinent to note that the above orders of APRC were issued under Section 86(1)(b) of the Electricity Act and Clause 8(1) of the APRC Business Rules of Commission. SRLDFC has also directed Andhra Pradesh State Load Dispatch Center to continue with the existing scheduling procedure as in force since 2/6/2014. In gross violation of the orders of APRC, the directions of State Load Dispatch Center, Government of Andhra Pradesh has not supplied power of so-and-so, etc. Those are mentioned. Had no alternative except to purchase power from market at high cost. This cancellation of PPAs and non-scheduling of power has deprived Telangana its legitimate share, and consequently Telangana was forced to purchase high-cost power from market incurring an additional cost. These facts were brought to the notice of Ministry of Power and also the Ministry of Home Affairs, Government of India, in various meetings, and written representations were also submitted. Specific provision of AP reorganization, I am not reading that. As power, para A, as power utilities have filed cases in NCLT with the pre and insolvency and bankruptcy court to settle the power purchase dues of Telangana discounts by appointing IRP. This case was withdrawn by AP Genco on 3/9/2021. AP Genco has filed petitions also in Honorable High Court to direct Telangana Power Utilities to pay amount. This petition was also withdrawn by Andhra Pradesh. It is pertinent to note, Andhra Pradesh has litigated on this issue before multiple legal fora without getting any legal relief. Then Miller Para 9. Telangana Discoms have filed OP 59 of 2018 before TSHC, and the Honorable State Commission has directed Andhra Pradesh Power Utilities not to take any coercive measures against Telangana Discoms. I have already placed that order. Telangana, if power utilities have then filed cases in High Court with a plea to pay the dues by Andhra Pradesh subsequent to bifurcation of the state that are rightfully owed to Telangana discoms. In the above petitions, issues related to debt servicing of Anantapur and Kurnool districts, cost incurred by Telangana discoms for market purchase of power, Telangana share of investments in employees trust, share of discoms and FRP bonds retained by AP Genco by raised among others. In all, the plea of power utilities of Telangana was that a total amount of 17,824 crores, including interest is receivable from Andhra Pradesh. Even if the payables to Andhra Pradesh are considered and netted off, still an amount of rupees 12,940 crore is receivable by Telangana Power Utilities as detailed in Annexure 1. These writ petitions are still pending and the matter is sub judice. This subject was also discussed in interstate council meeting. It was recorded in the minutes of meeting dated 4/8/22 that the matter was referred to Law Ministry by the Ministry of Power and the Law Ministry has conveyed its opinion to Ministry of Power. According to which, since the matter is sub judice before court of law and during pendency of dispute between AP and Telangana, it would not be appropriate for Government of India to issue any direction. Government of India, in whom the Act vests the power for intervening within a period of 3 years from the appointed date, based on the request of either state for just and equitable transfer of property and other benefits as per Section 66, cannot issue orders on matters relating to power granted as per Section 92, which is in relation to infrastructure and special economic measures. Section 92 is extracted. Even a cursory look at the 8 points extracted below make it abundantly clear that any guidelines or orders of the central government may or pertain to infrastructural needs and not financial liabilities, those are set out. Even Section 13, even Section 66, which entrusts the power to order allocation or adjustment in certain cases to central government, not only limits it to a period of 3 years from the appointed date, but also clearly states that they may intervene only upon a reference made by either of the states. In this case, no reference was made under Section 66 to the central government by Andhra Pradesh. No consultations were held. Even if any such reference is made, the same cannot be construed as reference under Section 66, as Telangana state was neither given any information nor was put on any notice within a period of 3 years from the appointed date, and the powers of central government ministries do not extend to issuing an order to one state to pay the other any amounts that may or may not be due as on the date of issuance of the present order dated 29/8/2022. To issue an order unilaterally 8 years after bifurcation of the state without considering the issue raised by Telangana Power Utilities, while the apportionment of assets and liabilities is not yet complete, is not only against the principles of natural justice, but also in gross contravention of the provisions of AP Reorganization Act. Further, it is completely one-sided and causes great financial injury to the power utilities of Telangana. In view of the above, dated 29/8/2022, issued to the government of Telangana Discom under Section 92, may be withdrawn immediately, as the said direction is in violation of the provisions of AP Reorganization Act, and also since the matter is sub judice. There are many issues pending resolution among power utilities of AP and Telangana due to bifurcation. Power purchase dues are one among them. If all the issues are settled, Telangana Power Utilities have to get rupees 12,940 crore after netting of the power purchase rule. It is requested that all the bifurcation related issues of power utilities may be seen and protracted instead of payment of power purchase dues alone. Now, no response was received to this. Then we had no option but to file the petition. I have to show only 2 other documents. One is the order passed by the State Electricity Commission, which is page 54, to which a reference has been made in this communication also. Page 54 of the same petition. Yes, page 54. This was in the pursuant to a dispute having been raised when AP sought to cancel all the power purchase agreements. We moved the state commission and this order is passed 11/8/2014. And this order has not been challenged. Now, very interestingly, I am skipping most of the paragraphs. Page 61. Paragraph 28. Yes. Page 61, paragraph 28. Because PPAs were executed before the reorganization, then government orders were there in regard to sharing of power. Therefore, Miller, the commission notes PPAs by themselves are not adequate for implementing commercial transaction of sale of power. They have to be read in conjunction with government orders on sharing as well as APRC orders on tariff. It can be argued that these two recommends, government orders and APRC orders, are more fundamental than the other two components. As mentioned, PPAs are at best a statement of technical commercial. It can thus be argued that cancelling a PPA cannot nullify a transaction which has its components outside the PPA and not mentioned within it. Then, Millets, kindly come to page 66, the legal position, and they set out the provisions of the Act. And Millett, page 69, issues for resolution. PPAs void for want of Commission's express content. Is the withdrawal of PPAs valid? And can PPAs be unilaterally reciprocated by AP Genco? That's issue number 2. And Miller Commission's analysis starts at page 70. Miller, on the first part, I'm not covering my lots. And Miller, page 78, straight away, Miller. Paragraph 77. Based upon page 78, paragraph 77. Based upon the detailed analysis of the implications of the Andhra Pradesh electricity regulation, EA Regulation 1 of 2008, as well as other considerations described in paragraphs 53 to 76 above, Commission holds that the PPAs under dispute cannot be found void, nor can they be deemed void for want of Commission's formal approval, because this was one of the contentions of AP Genco. Then Miller, issue 2. Is the withdrawal of PPAs valid and can such PPAs be unilaterally rescinded by AP Genco? Then Miller, the arbitration provision in the PPAs mentioned, differences or disputes between parties arising out of or in connection with this agreement shall be endeavored to be settled amicably through negotiation between chief executives of the respective parties, failing which shall be settled by arbitration. In the event of any such differences or disputes between parties, any party may, by a written notice of 30 days to the other party, request Andhra Pradesh Regulatory Commission to settle such dispute. And this will cover every dispute, including in regard to payment. Now, page 79, para 81, PPAs must specifically mention disputes must first be settled by prior negotiation, and APRC should be approached for resolution. AP Genco has manifestly not followed the procedure prescribed in the PPA with regard to alleged dispute. It has with the Telangana Distribution Company on the validity of PPAs. There was no prior meeting of chief executives. No reference was made to APRC. No notice. Further, AP Genco has issued these termination notices unilaterally. No notice was given to any of the DISCOMs about AP Genco's intention to disavow the PPAs. This violates principles of natural justice. Then Miller, page 81, para 88. For the reasons mentioned in para 78 to 87 above, Commission finds this is a case of withdrawal from an agreement without notice, without capacity, and in deviation from the procedure prescribed in the PPS for dispute resolution. Accordingly, Commission holds that withdrawal of PPS by AP Genco is not valid. Now, various other things are set out. I don't think I'll trouble my lords with it. Summary of findings is at page 90. Para 97, 98. Summary of findings. This order has not been challenged. Therefore, PPAs are valid. You can't unilaterally withdraw. You have to supply power. Therefore, it is under the PPAs that supply has been made. When they sought to recover some monies allegedly due in regard to supply of power, we moved APERC, the Telangana State Electricity Commission, and Millard got the interim order, which I have already placed. I am not troubling my lords again. Now, Millard, when we moved the commission, they filed the writ petition. I have, last time I didn't have the copy of the writ petition filed by them. I have copies now. May I just hand over the copy, Millard? The affidavit in support of the writ petition. This petition had been filed as a petition. Study from how it go. This is yes, writ petition, the number should have been mentioned. It is writ petition 42577 of 2008. 42577 of 2018. And this has been filed on 22nd November 2018. My lords will see at the foot of the page. Even before the order was passed, interim order restraining them from taking any coercive steps, which was passed in December, this writ petition was filed. And the phrase are at page 18 of the affidavit. In view of the above, it is therefore 6 minutes. It is therefore prayed that this honorable court may be pleased to issue any appropriate writ, direction, or order, more particularly one in the nature of writ of prohibition, declaring that the action of the first respondent in entertaining and proceeding with OP number 59 of 2018 and IA number 34 of 2018 as illegal, arbitrary, and lacking jurisdiction, being violated and as contrary to the provisions of Electricity Act 2003 and AP Reorganization Act in the interest of justice, and pass such further order. Interim order restraining, seeking to restrain all further proceedings. No interim order was granted. And what is more interesting is, after the order was passed by the State Commission, restraining them from taking any coercive step, which order was passed on 29 December 2018. No other application, no amendment was made to the writ petition. No application was sought for staying the order of the Regulatory Commission. I have already placed the order, I am not troubling my lord. That is dated 29 December 2018. No amendment was sought. No prayer was made for restraining the implementation of this order of staying the order. And Miller, that order even today continues. Yes. And Miller, they had appeared. They had appeared. I have already pointed it out on the last occasion. I am not troubling my lords with that. They have not filed any counter. They had appeared, etc. Now, Miller, all these facts had been brought to the notice. Now, Miller, there is not even a consideration of any of these pending matters. And Miller, the impugned order proceeds on the basis it is as if there is a dispute between the two states, because otherwise they won't get jurisdiction under Section 92. And Miller, the direction is issued to the state of Telangana to make payment to the state of Andhra Pradesh. That, my lords, have seen at page 37, 38. In fact, the draft order I showed Miller on the last occasion, draft order said that the state discoms in Telangana should make payment to the GENCOs in Andhra Pradesh. That I don't know how, Miller, because the notes file doesn't disclose the amendment made to the draft order. But the final order that has come is what is seen. Miller, I have already placed that order. And Miller, final order refers to the successor state of Telangana shall pay the amount to the successor state of Andhra Pradesh. Now, my lords have seen Section 92. It is only the direction can be issued only to the successor state. It can't be issued to the GENCO or to the DISCOM. And therefore, apparently, this impugned order is now couched in the language where successor state of Telangana will pay to successor state of Andhra Pradesh. Though they are not parties to the PPS, and PPA is governed by the provisions of Electricity Act. Now, let's kindly have a look at the Electricity Act. Section 86. Section 86. 1. The State Commission shall discharge the following functions, namely, I'll skip all these A, B, C, D, etc. Kindly come to Millet. Yeah. 86.1F. Adjudicate upon the disputes between the licensees and generating companies and to refer any dispute for arbitration. Therefore, if under the PPA, there is a dispute in regard to any payment to be made under the PPA for supply of electricity, and the dispute is between licensees and generating company. Kindly have a look at licensee definition, section 2, subsection 39. 239, licensee. Licensee means a person who has been granted a license under section 14, and I am a licensee, and the licensee is under 14. Section 14, the appropriate commission may, on an application made to it under section 15, grant any person's license to any person to transmit electricity as a transmission licensee, to distribute electricity as a distribution licensee, or undertake trading. And the DISCOMs here are granted license to distribute electricity as a distribution licensee. Therefore, it's a, and generation companies do not need any license. That's why Miller expressly, section 86 says, adjudicate disputes between licensees and generating companies. And Miller, the claim is by generating company who has supplied electricity under the PPA to the DISCOM, Telangana DISCOM, who are licensees. Therefore, this is a dispute which squarely falls within the functions of the State Commission. And Miller, the Telangana DISCOMs have in fact approached the State Commission, which has granted in regard to this very dispute. And Miller, the State DISCOM, Regulatory Commission has granted an interim order restraining the GENCOs of Andhra Pradesh from taking any coercive steps, which order has not been challenged, has not been stayed, and is in force. Now, in the teeth of this, they went with the NCLT for winding up of the company, withdrew, writ petition filed, withdrawn, in this honorable court, withdrawn. My writ petitions were pending in regard to recovery of money from them, all of which have been set out in the petition to which I have drawn my lord's attention. I don't want to take my lord's again through that. Now, with this, I respectfully submit, this is not a matter in respect of which an order could have been passed. Now, kindly have a look at section 92 again, since the order has been issued under section 92. Of the AP Reorganization Act, section 92 of the AP Reorganization Act. The part heading is part 10. Infrastructure and special economic measures. And section 92, under the marginal heading, successor states to follow principles, guidelines, etc., issued by central government. The principles, guidelines, directions, and orders issued by the central government on and from the appointed day on matters relating to coal, oil, and natural gas, and power generation, transmission, and distribution, as enumerated in the 12th schedule, shall be implemented by the successor state. Essentially, in respect of principles, guidelines, etc., in regard to how the sharing is to be done. Once, and the schedule itself sets out how schedule existing PPAs continue. 12th schedule C2.
27.
Whatever are the consequences under the PPA, whatever are the terms and conditions that will be binding on the parties, no adjudicatory power is vested in the central government. No direction can be issued in regard to a dispute arising under PPA because PPA continues, PPA governs. And I don't think any decision is needed, but I want to give one decision which more or less deals with a similar provision. Kindly have a look at 2010, Volume 4, SCC 603. This is PTC case where the bench of 5 honorable judges interpreting.
603.
2010, Volume 4, SCC 603, PTC versus CERC. I got
Keep a list of cases here, not whatever.
Justice Kapadia, as he then was speaking for the bench, and Millard in para 2. Whether the appellate, I'm sorry. The questions of law. The crucial points that are raised for determination are whether the appellate tribunal constituted under the Electricity Act has jurisdiction under Section 111 to examine the validity of CERC, Central Electricity Regulatory Commission, a fixation of trading margin regulation framed in executive power conferred under Section 178. Then Miller 2 is the one in respect of which I am drawing my Lord's attention, whether Parliament has conferred power of judicial review on the appellate tribunal for electricity under Section 121 of the 2003 Act, whether capping of trading margins could be done. Now kindly have a look at paragraph 83. May first read paragraph 88. Paragraph 88 extracts the section para 88 in page 648 of the reports. Power of appellate tribunal. Appellate tribunal may, after hearing the appropriate commission or other interested party, if any, from time to time, issue such orders, instructions, or directions as it may deem fit to any appropriate commission for the performance of its statutory functions under this Act. This was the provision which was being construed. And Miller, kindly have a look at para 83. In fact, Miller, the Raman case is referred to where state government had the power to issue orders and direction. Applying the test, applying the test laid down in the above judgment, Raman, to the present case, we are of the view that the words orders, instructions, or directions in section 121 do not confer power of judicial review in the tribunal. It is not possible to lay down any exhaustive list of cases in which there is failure in the performance of statutory function. Then will they go on and kindly see one more paragraph, paragraph 92. Where they summarize the provisions and subparagraph. Section 121 does not confer power of judicial review. Words, orders, which in para 92 subparagraph page 649 and 650. Yeah. 650. At 650 subparagraph 4 million. Section 121 does not confer power of judicial review on appellate tribunal. Words, orders, instructions, or decisions do not confer power of judicial review in the appellate tribunal. In this judgment, we do not wish to analyze English authorities, etc. Now, I respectfully submit there is no judicial power which has been conferred here at all on the central government. Now, if no judicial power has been conferred, an administrative order to make payment in this manner without even hearing her, and I respectfully submit is not a power which can be enforced on her. I have given a written submission. I don't propose to take my lords through the entirety of it.
When?
I believe on the last occasion I had given a note which had a 2-page overview and yes. I was supposed to read again, but kindly come to what I have done. Page 4. I have given a note on the case law summarizing, and I have given an index And if I may take my lords quickly through that index, submissions regarding section 92, section 92 does not impose central government to perform adjudicatory judicial function. Object and purpose of the section is not to confer adjudicatory judicial function on central government, nor sit at exercise with respect to expression, principle, guidelines, directions, and orders. Adjudicatory order passed by the executive central government without jurisdiction power to perform such function is a nullity. Central government cannot usurp, encroach upon judicial function, which is the express power of the judiciary. Central government has directed state of Telangana to make payment without following any procedure required to be followed for adjudicating any dispute. Then case law summary table, an adjudicatory order passed by executive government without jurisdiction power to perform such function is a nullity. Government cannot encroach on, take over, usurp judicial function power. Manner of and principles to be followed in determination of dispute, purposive route. Well, I don't have to read any decision. My lords have authored books on these. Therefore, it will be inappropriate for me to even attempt to place those decisions. But I'll quickly refer to just one or two decisions, and that also I don't want the books to be taken out. I have extracted them. Kindly come to the page 5, I have set out the object and purpose. I'm for interpretation. My lords know the rules. I don't think I should trouble my lords reading that. Then page 6, object is not to confer adjudicatory judicial function. Then kindly now come to page 7. Subpara C. Central government cannot usurp, encroach upon judicial function, which is the express task of judiciary, without prejudice to previous submission must be noted. Central government cannot usurp judicial functions and tasks which are specifically to be performed by a specially created organ of the state, that's the judiciary. Adjudication, including determining rights, liabilities, etc., require careful judicial procedures to be followed, and therefore the same cannot be encroached upon or usurped by the central government. On the contrary, usurping such judicial function is a violation of the principle of separation of power, which is a part of the basic structure of the Constitution. Moreover, such usurpation by central government is in the teeth of express provisions of the Constitution, whereby the only and exclusive forum for determining a list for payment of dues between two state governments is expressly conferred on the Supreme Court of India. Number 130, but if it is between two state governments, if it is here, as in this case, under an agreement between GENCO and DISCOM, the jurisdiction is with the Electricity Regulatory Commission with an appeal to the appellate tribunal, etc. Now, kindly come to page 9 of this. I will read only from this note itself instead of taking the books. I've extracted from some paragraphs. Indira Gandhi, my lords are familiar, the judicial function is a part of the basic structure. I don't want. Serial number 3, Kalpana Mehta, essential functions entrusted to one organ of the state cannot be exercised by the other. Then the reference is made by standing against the usurpation of constitutional powers entrusted to other organs. Separation of powers supports the rule of law and guards against authoritarian excesses. Judiciary decides and adjudicates upon disputes in the course of which facts are proved and law is applied. This has been indicated as an essential judicial function. Nuances of the doctrine of separation of powers recognize that while the essential function of one organ of the state cannot be taken over by the other, and that a sense of institutional committee must guide the work of legislature, executive, and judiciary, the practical problems which arise in the unfolding of democracy can be resolved through robust constitutional cultures and mechanisms. Then, on Punjab Termination of Agreement Act, this is after the Supreme Court in the water disputes case between Punjab and Haryana. Justice Romapal, Justice Patnaik, I believe, gave a decree. They sought to the law and to set it not, like what Karnataka did when Kaveri Tribunal passed an interim order. And it was in this context the observation was made, no government, whether central or state, can usurp the power of adjudicating disputes vested in the judiciary, including the High Court and the Supreme Court. The Constitution grants and recognizes supreme authority to the courts to not only interpret but also to protect the Constitution and the law. Dadu, judiciary must ensure that the executive branches of the government do not transgress, exceed the limitation. Judicial review is the heart and soul of the Constitution. And then Miller I.R. Coelho, it's a 9-judge bench. Equality, rule of law, judicial review, and separation of powers. So the basic structure of the Constitution. Judicial review and separation of powers. Each of these concepts are intimately connected. There can be no rule of law if there is no equality before the law. All these would be redundant if the legislative, executive, and judicial powers are vested in one another. Therefore, the duty to decide whether the limits have been transgressed has been placed on the judiciary. Ram Javai Kapoor, I don't propose to read that. Then the second part is, when there is a claim, if it is a civil court or even before the state commission, I am entitled to either set off, make a counterclaim. And in any civil suit, any adjudication, both these will be considered. It can't be only one. I'm entitled, if I'm entitled to a set off, I will make that. If I'm entitled to a counterclaim, that again will be adjudicated. Then whatever remains will have to be. Now, till such time as these are sorted out, one side can be asked to make the payment. And the settled principle in regard to there can't be adjudication so moto by unilaterally by one party. That is well settled by Ramalayan Foundry and that line of cases. I don't want to read all that. And just to on the natural justice, kindly similar serial number 9, S.K. Bhargava, in a dispute requiring determination of a sum due, principles of natural justice, especially hearing the party from whom the amount is sought, must be followed. Well settled. Then Harbhajan Singh Dalla, if administrative authorities are enjoined to decide, right, even if proceeding, Section 92 confers the power on the central government to decide, then should afford fair and hearing to the persons to be affected by the order and give sufficiently clear and explicit reasons. Assuming Section 92 confers such a power, then I must have been heard, I must have been given proper opportunity, and thereafter, a reasoned order should be there. There is no such order. I respectfully submit, therefore, on all these grounds, this impugned order is invalid. Now, the question of whether even a law with reference to Article 3 and 4 can violate any part of the any provision of the Constitution of India or will have to conform to it. There are a number of decisions. I don't think it will be necessary for my lords to go into it because I don't think it can possibly be contended by them that Section 92 can even violate the basic structure of the Constitution which requires supremacy of judiciary or separation of powers. Because judicial adjudication will have to be today under the separation of powers only by judiciary, it can't be by executive. I don't think it can be argued, but I have, by way of abundant caution at each dealt with very cases where laws have been passed under Article 3 and 4. R.C. Podyal is that case, Sikkim, where Sikkim merged, and in that context, the observation of the Supreme Court Constitution bench. I believe this is Chief Justice Venkatachalaya. Is limited by the fundamentals of Indian constitutionalism. Because Article 3 and 4 are telling that. Law made thereunder cannot be inconsistent and irreconcilable with the foundational principles of the Constitution and cannot violate or subvert the constitutional scheme. Terms and conditions of such a law should not seek to establish a form or system of government or political and governmental institution alien to and fundamentally different from those the Constitution envisages. Then Mr. Mangal Singh, this was in the context of parting with some of the territory of India. Power under Part 1 has to be exercised as contemplated by Constitution, and it's not a power to override the constitutional scheme. Power with Parliament, with which Parliament is invested by Articles 2 and 3, is power to admit, establish, or form new state, which conform to the democratic pattern envisaged by the Constitution. Then, in the very context of Telangana judges, under the same AP Reorganization Act, 2019-18 SEC, judiciary should be independent of the executive is a constitutional objective and also a directive principle. Power under Articles 2 and 3 is subject to other provisions of the Constitution and is not unfettered. Provisions of Andhra Pradesh Reorganization Act have to be interpreted in the manner so that any provision of the 2014 Act do not treat the existing constitutional scheme. Then, the state of Himachal Pradesh, this was in the context of the claim made to electricity. Parliament cannot, that was Punjab Reorganization Act, where new state of Himachal Pradesh, etc. were formed. In that context, under Article 3, Parliament cannot take away the powers of state executive or state leader in respect of matter. But I don't think I need to trouble my lords with this. And last 3 minutes, Lafarge. Whenever a new state is created, there would be difficulties and issues would arise, but these have to be dealt with within the parameters of the constitutional provision. Now, there are a number of issues. I have already referred to those documents where the claims are there. They have filed it. A comprehensive petition has also been filed by State of Andhra Pradesh now. And notice has been issued. Government of India has taken time. The matter is listed in November. In this, you can't have piecemeal either adjudication or executive orders, directions being issued, which takes away my valuable rights and will put me to great prejudice. Reference is made in the counter affidavit. I want to place 2 or 3 paragraphs of the counter affidavit only, and I am done with that. Kindly have a look at how the government of India has sought to defend the order. I won't even trouble my lords with the counter affidavit filed by the Telangana Genco. Number 1, Telangana Genco, there is no, they can't possibly defend the order, impugned order. Impugned order is not passed by them. Secondly, according to them, the dispute is between state, Andhra Pradesh Genco, not Telangana. My mistake. my apology. Andhra Pradesh Genco. Counter affidavit. Answer. Sometimes the truth comes. But the truth is, AP Genco has filed. The Telangana Genco is not supplying power here. There is no. Please see the counter affidavit filed by the government of India.
No, government of India. Madam, this is respond number 5.
Respond number 1.
1.
5 is the AP Genco.
Yeah. I respond number 1.
Mr. My learned friend, Mr. Mohan Reddy, sir. AP Genco. Yes.
Rule. R1.
I mean, this affidavit was filed, I believe, on 11th October 22. I mean, filed on 14/10. The affidavit is dated 11th October 20.
Yes.
Yeah. Now, kindly have a look at, this has been sworn to by Deputy Secretary, Ministry of Power, Anup Singh Bisht. And it is in paragraph 6, it is respectfully submitted that the AP Reorganization Act was passed by Government of India to lay down provisions relating to reorganization of existing state of Andhra Pradesh or fund for matters connected therewith. It is pertinent to submit that the Government of India, Ministry of Power, with a letter dated 29th August 2022, issued direction to Government of Telangana for discounts under Section 92 to make outstanding payment of power dues to Andhra Pradesh for electricity supplied to. There is no direction to power discount. There is obviously a mistake, and that is repeated subsequently. Para 7, it sets out position. In the central government, third line, central government is empowered to lay down principles, guidelines, directions, and orders to successor state on matters relating to power generation, transmission, and distribution. Now, not to discoms, not to GENCOs, and not in regard to payments, etc. Then, kindly see para 8, and I would, I am sure the Government of India will show what documents they have, because I have placed all the documents. Please see para 8. This is a factually incorrect statement according to me. The last 3 lines, it is respectfully submitted that central government have heard both the state government of Andhra Pradesh and Telangana before passing the order. And I respectfully submit, actually, yes, yes, and the file I have shown. Then para 9, 5th line, at the Union of India Ministry of Power has issued direction dated 29th August on the power vested in it by the Reorganization Act. The power to give directions to supply electricity by one state to another has a necessary corollary, the power to give direction payment of the electricity so applied. The Government of India never gave any directions to AP GENCO to supply power. The Act provides that the PPA will continue. PPA was directed to be followed. There is no exercise, no direction issued alien day without reference to the PPA. That the Act itself provides that the PPA continues, and the POSOCO directed, Government of India was nowhere in the picture. Then kindly come to paragraph. Please also incidentally see paragraph 10 and 11. Union of India is so solicitous of paragraph 10, last line at page 5 of the affidavit. Power dues are payable by Telangana. Power supplied by Andhra Pradesh are thus for actual cost for various inputs such as coal, employee cost, maintenance, working capital, etc. that have been incurred. I have made payments to the financing companies towards their working capital, for which I have to get the money from them. That is not taken into account. I have made my employees' funds are lying with them, which they have not given to me. That is not taken into account. But however, they are very solicited. AP GENCOs in regard to all this, which is repeated in para 11, third line. Generating companies have to pay for coal, employees, maintenance, working capital, etc. Keep the generating stations running. And outstanding power are adversely affecting financial viability of AP Genco. What about discount? If I make the payment and I recover from the discounts will be, their viability will be affected. Then paragraph 12. It is respectfully submitted that all other contentions raised by the petition in the present petition are relating to disputes regarding bifurcation between state of Andhra Pradesh and Telangana and are not linked with the outstanding. Section 92 itself is arising out of bifurcation of the state. Section 92 is incorporated in an act which is in regard to reorganization and the continuance of PPA after the bifurcation. Well, therefore, that is also a dispute in regard to this. Then paragraph 13. Third line, state of Telangana has availed the supply of power from AP Genco since its bifurcation from Andhra Pradesh under the provision. State of Telangana is legally bound to make the payment for electricity supply. They cannot deny the liability by taking frivolous and misleading stand. But I have gone to the appropriate commission, got an interim order. This is not a frivolous and misleading stand. I have gone and nobody has gone and even challenged that order granted by the AP Regulatory Commission, which is the appropriate authority under the PPA for resolving dispute. And how can anybody say this? 14. It is humbly submitted that the issue of power dues has arisen only after bifurcation of state and demerger issues between power utilities are independent. There is no rationale to link these two issues. I can't understand. In regard to these very issues, they have under the PPA failed to supply power. I had to purchase power at higher cost. I have raised this as a dispute. 6,800 crore is only on account of that. Because they failed to supply power, I have raised a dispute before the competent forum. And that is in regard to failure to supply power. Properties are reconciled and undisputed. But subject to all this, this goes on like this. And now kindly come to page 10, paragraph 13. A complete lack of application of mind to the order. Please see paragraph 13. Second line. Ministry of Power. Within the impugned direction has only directed state of Telangana and Telangana discoms. Telangana discoms have not been directed to pay the outstanding power dues of the generators of Andhra Pradesh. That is also incorrect. There is no direction issued to make payment to generators, but as if it is a direction to pay to the state of Andhra Pradesh. I respectfully submit the counter affidavit does not deal with the issues raised, and I respectfully submit, therefore, the order deserves to be set aside. And I am not traversing the governments of the AP Genco. AP Genco as a beneficiary, in fact, the state of Andhra Pradesh, the party has not filed any affidavit. State of Andhra Pradesh, who is the beneficiary, very well. Very well. Yes. Now, so far as AP Genco is concerned, I respectfully submit they are bound by the terms of PPA, and under the PPA, they should have gone to the Regulatory Commission. And if the AP Regulatory Commission has issued a restraint order on them, they should have gone and challenged. They can't. I'm very grateful, Melinda. Yes. Yes. The petitions filed by the discoms here against them are pending. The reference is made both in our petition and the discoms petition. My learned friend is appearing for the discoms. Okay.
No, I whatever it is. Only my concern is that the disputes with regards to that payment, that it is pending adjudication before the Honorable Court in respect of 3 writ petitions. That was the reason we made a mention before the Honorable Court, where my friend has not categorically opposed for not clumping up this writ petition with that writ petition. But therefore, I adopt whatever the arguments of the land CDI. Okay.
Solicitor General, additional to General my lord, he said he will
He will
virtually my lord.
virtually, yes.
I think.
Yes.
May,
Yes. Yes, Mr.
may please, Lord.
Yes.
Lord, so far as Lord, the union is concerned, Lord, under the provisions, Lord, of the Reorganization Act, Lord, we have got the power to issue directions with regard to coal, electricity, etc. And the impugned order has been passed in exercise of that power. And the argument, Lord, that opportunity has not been given, Lord, may not be correct. When the Lordship, Lord, was taken through the note file, Lordship had occasion, Lord, to see that the secretaries of both the states were present, and it was stated that there is no dispute with regard to the quantum of money that is payable, and only thing is that they say that they also had counterclaims. And so far as the consideration with regard to the counterclaims is concerned, the union has said that material was not placed before us to show on what basis the counterclaims are made, and therefore we are not delving into that question. And on the undisputed fact, the impugned order not has been passed. Therefore, the impugned order, in my respectful submission, would be traceable to the power that is available under the Act. And if it is traceable to the power under the Act, the only question, only issue on certiorari can be issued is either it lacks jurisdiction, or there is violation of principle of natural justice, or it is not arbitrary. My respectful submission is that when the two states are the creature under the Reorganization Act, and the Parliament has conferred power on the central government to issue directions which is binding on the successor states with regard to items which are contained in Schedule 12, and electricity which is being supplied by the gen companies is also an issue which is also an entry which finds place in Schedule 12, then it is well within the jurisdiction of the central government to take up the complaint or the representation that has been made by Telangana state Lord into consideration. While taking that into consideration, notice has been issued, Lord, to the Telangana state. They were also present. But what has happened in the other committee meeting, Lord, under the Home Ministry, which was adjourned to 3/9/2022, Lord, keeping that aside, what was considered, Lord, by the Ministry of Power, which dealt with the matter. Before the Ministry of Power, there has been an admission with regard to the quantum. On the basis of the admission with regard to the quantum, the present impugned order, Lord, has been passed. Lord, Lords may kindly see, Lord, the impugned order at page number 40. Lord, in 37555 of 2022.
We'll look into it. We'll look into it.
Direction for payment of power dues by the government of Telangana, power discoms, to Government of Andhra Pradesh under section 92 of the Andhra Pradesh Reorganization Act 2014. Whereas Andhra Pradesh Reorganization Act 2014 came into effect from 2014, whereas Schedule 12, section 92 of Andhra Pradesh Reorganization Act inter alia provides power existing power purchase agreements with respect to discoms shall continue for both ongoing projects and projects under construction for a period of 10 years. The successor state that has deficit or electricity shall have first right of refusal for purchase of surplus power from the other successor state. Whereas Power System Operation Corporation, in their letter dated 18/6/2014, conveyed that during the meeting held on 28/3/2014, APSLDC shall continue to supply power according to the schedule in force so and so. In accordance with the decision taken, Abgenco supplied power to so and so. Whereas Abgenco had supplied power to Telangana discoms post bifurcation from 2/6/2014 to 10/6/2017 under clause 2 of schedule 12 of AP Reorganization Act. So this issue related to power supply dues. Representations have been received from state of Andhra Pradesh that Telangana has not paid for the power supplied to the state from 2/6/2014 to 10/6/2017. Whereas there is no dispute regarding the amount to be paid for power dues, the principal amount being 3,441.78 crores, late payment surcharge being 3,315.14 crores up to 31/7/2022 to be paid in addition to the principal amount as per applicable provisions. Every right of one party entails a corresponding duty. Right and duty are conjoined, and as such, Telangana must pay the power dues to Andhra Pradesh for electricity supplied to them under the orders of the Government of India issued under the Andhra Pradesh Reorganization Act. Therefore, Government of India, in exercise of powers vested in it under Section 92 of AP Reorganization Act, hereby orders that the successor state of Telangana shall pay the due amount as mentioned in this order to the successor state Andhra Pradesh within a period time frame. But my respectful submission is, if your lordship kindly see Section 92, the power to issue directions plot is contained. And power to issue directions with regard to matters concerned in Schedule 12. Schedule 12 refers to the power purchase agreements which shall continue in terms of those power purchase agreements. But so far as the complaint brought by them that power purchase agreements plot has not been continued because of non-payment if one party does not continue to supply the power, and therefore on 10/6/2017 power supply has been stopped. That is a different issue. Payment for the period 2/6/2014 to 10/6/2017, it is not the case of Telangana that they have paid, and therefore there is no due. On the other hand,
So your submission is like as we have this thing that there is no element of adjudication in the order.
Yes.
It is in fact based on an admitted liability.
yes, Lord. Yes, Lord. I rest my
And
case with that.
what about hearing, opportunity of hearing as contended?
Lord, they have been given the opportunity of hearing. If your lordship kindly sees, Lord, the note file on 8/11/2021. On 8/11/2021, minutes of meeting has been recorded in which, Lord, the state of Telangana has also
what
very much participated.
Date.
8/11/2021. In that meeting, the secretaries of both the states, Lord, they were present. And that is available, Lord, in the file that has been circulated, Lord, to your lordships.
Yes.
I'll ask my friend, Lord, to flag the pages, Lord, and give it to your lordship, Lord, which records the presence of them. And while they...
Last occasion I provided, my lord, the 2 copies of the note file, and lordship has
yes.
shield cover it is there. Lordship again, page 4N.
Note copies, right? Like photocopy is there.
That is
Apart from seal cover, madam, there is one photocopy.
page.
Wherever, get it.
That para number 6, my lord.
Para
6.
6 of the order dated 8/11/21.
Note 5.
No, this para 6 refers to what date? 8/11/21.
Yes, 8/11/21, my lord. 8/11/21.
Yes.
Lordship may also kindly see page number 1, 2, Lord. Page number...
How does it read? Please, can you read it? Para 6.
Lord, I'll refer to it, Lord, in another note also. Lordship may
Shall I
kindly take...
For time being, my lord, pass it on.
Lordship may kindly take, Lord, the note file, page number 12. It is, my lord, DY number 414772 bar ADVB bar 2022.
Page
1, 2. Page 12 or 13. The 2 pages are carrying the same number, blood. Page 13, your lordship may kindly take, blood.
Yes.
as desired by the Honorable Minister for Power. Lord, am I right, Lords?
Yes, yes. Yes.
As desired by the Honorable Minister for Power, Ministry of Power has referred the matter for seeking advice of this department on their proposal to issue order in terms of Section 92 of the Andhra Pradesh Reorganization Act 2014, asking the state of Telangana to make outstanding payment of dues for power to state of Andhra Pradesh. As mentioned in para 1 at page 7(n), the Honorable Chief Minister of Andhra Pradesh sent a DO letter dated 14/7/2021 to the Honorable Prime Minister regarding non-payment of power dues of rupees 6,111.88 crore by Government of Telangana for power discoms for supply of power by Abgenco to Telangana Discom post bifurcation from 2/6/2014 to 10/6/2017 as power deficit faced by Government of Telangana during the said period. It has also been requested in the DO letter to deduct it from the union devolutions of Government of Telangana and settle the dues. Copy of the DO letter is flag B. In order to resolve the matter, Secretary Power chaired a meeting with representatives of Government of Andhra Pradesh and Government of Telangana on 8/11/2021. As recorded in the minutes of the said meeting, following facts amongst other emerged after deliberation in the meeting. There is no dispute of the principal amount to be paid for power supplied by Andhra Pradesh to Telangana. However, some reconciliation is required on the interest to be paid on the principal amount by Andhra Pradesh to Telangana. Both the states agreed to reconcile the figure as per the terms and conditions of the power purchase agreement. That the minutes of the meeting dated 8/11/2021 is available blood in another file blood which contains blood the correspondence blood which is all referred to in this note. Blood that minutes blood we can pick it out blood and give it to your lordship blood.
Where is it?
Another file is there blood with my learned friend blood.
Yes, Mr. Another file.
And the lordship may also kindly take 5/6/2022 letter that is written blood to the Ministry of Home by the state of Telangana. They are admitting the dues blood to the tune of rupees 3,441 crores.
Where is it, Mr. 5/6/22?
Yes, that's
Blood of page number 142.
1 minute.
that is there. No?
Where?
It's fine.
No, correct. Where is that?
I'll take that copy.
Page?
No, that is there on page 93, my lord. That's
And which page?
on that notice there, my lord.
Page 222. Same, which you have read. Mr. Vaidyanathan, you have read this letter written by this thing. The minister.
It was written by the Honorable Minister, my lord.
T. Harish Rao.
Yes.
Not, it is available not in the typeset of papers. The paper book in.
He may not have. Yes. Rate petition, there is you will find that at page 142.
142. I'm drawing your lordship's attention.
Possibly-
Blood.
Yeah, 37599 of 2020.
Yes, blood. 37599 of 2022. Blood at document number 33, exhibit P29, dated 5/6/2022 at page number 142. Blood, lordship may kindly take page number 143. Page number 143 at the bottom of the page, blood. Payable to Abgenco for power purchased by
From the state of Telangana.
Yes. Yes.
the figure, your lordship will get it.
142.
Yeah.
You have. Yes, please.
Therefore, blood, my respectful submission is,
What is it you want to read? Where is the admission?
blood, lordship may kindly take the second page of that letter at the bottom.
Ah.
Payable to Abgenco for power purchase, the last entry.
Yes.
Payable to Abgenco for power purchase by TSPCC 3442. Then interest at 10.5%. Then total. This is blood, a letter blood by Government of Telangana, the Minister blood from Government of Telangana. Thereafter, they are coming forward blood with the other claims that for all other reasons, something is payable to them.
Oh, but this thing you have got some figure by way of surcharge in the order standard 92.
Blood, surcharge is payable as per the provisions of law. If the amount is not paid in time, it is not covered by the provisions of law.
Which provision?
Blood, under the Electricity Act itself, blood.
Please file. Because see, if you are relying on admission, then what we are immediately getting is that this amount of surcharge is not admitted. They have only one. They have admitted the principal amount of 3,442, even assuming like this, what you are at page 143. Then we admitted interest at the rate of 10.5%.
10.5% blood is 1446.
That
is 1,446.
And please see, and please see the figure at which surcharge is 3315. So the question comes, where from have you got this figure? This is, if it is based on admission, then this, all right. But surcharge, where from have you got this figure?
It is only by applying a higher rate of interest.
And how, which?
It's by virtue of the PPA. When I supply power, but there is a delay in payment. The PPA method provides.
You will tell us the clause, right? All right. All right. So it's under PPA, Mr.
Yes, brother.
It's under PPA that you are, our party to whom payment is not made is entitled to surcharge.
And one
therefore, if you are saying, like we have understood, that both the parties were given like a notice and this thing, they were present, and there is no element of adjudication, right?
Yes, brother.
Therefore, even assuming that if it is like an order passed on an admitted liability,
it's a direction to pay on the basis of
admission.
And once the principal is admitted, the BPSC will not follow.
See, this first we have understood that 3,442 crores admitted by Telangana.
Yes,
and this surcharge, where is the admission that they are entitled to pay surcharge? This is as a, once you are saying that a necessary corollary. Once principal amount is admitted, the surcharge automatically follows. Something like that.
My learned friend blood would show the class blood in the.
Yes, that is. Yes.
And one other contention which I have to blood answer to your lordship, blood senior counsel argued that power is available only to give direction to the state, whereas the liability for payment is on the discoms, and therefore it was not traceable to section 92. Blood, there cannot be a hair splitting blood consideration like that, splitting the state and the discoms. Blood, they are all blood wholly owned blood by the government, and the intention so far as the power supply and directions to be given is concerned, it refers to the discoms also by referring to the power purchase agreements as an entry in schedule 12. Therefore, if it is interpreted as if that directions cannot be given, which will be blood enforceable against the discoms or the state, then blood it will lead blood to an absurdity where the power to give direction under section 92 would become meaningless, and it would become blood just written on paper without being addressed to anyone who is responsible to pay. Therefore, the state and the discoms go hand in hand, and the direction under section 92, which refers to directions given to the state, read with schedule 12, which refers to the power purchase agreement which has been entered into between the generating companies and the discoms. If it is read as a whole, then our order directing the state to pay blood is correct. Blood. I rest my submissions blood with this blood.
That's it, Mr.
Yes, blood.
Okay. You could continue for another fifth because no other case we can take.
Yes,
so please begin. We will continue some other.
Not to excuse me, minutes.
Yes, Mr. Sundaresh. Yes.
Already your lords posed a question just now as to the surcharge. But I'll answer that first,
Because what he said was it is based on an admitted liability.
It's an admitted liability.
Liability. So this thing we just wanted to know where from this figure has come then 3,000. Because what he showed it's only one double.
The documents filed along with the.
You are appearing for?
I'm appearing for respond number 5. Document sign just what on the page number in the order.
In WP 37599, right?
Both the matters.
AP Genco.
Right, I'll point out that one is as well as the fact that Regulation 1 of 2004, framed by the APERC, Resfile APERC, provides for surcharge for related payment. Therefore, it's mere calculation as to what is the amount liable to be paid.
So once principal sum is admitted, right?
Yes.
Then it follows.
It follows. Now, there are 2-3 aspects before the court raises what I thought I should make clear. One is the contentions raised by the learned senior counsel that there was a determination of the PPA by the state of Andhra Pradesh, and therefore there was no supply of power to Telangana. They had to purchase power from outside sources, and therefore they had incurred some 6,000 and odd crores. Therefore, it's also claimed by the state of Telangana. We're not forgetting about the other claims that arose prior to bifurcation. And our outcome of the bifurcation. Insofar as that's concerned, every unit of power that's liable to be supplied by the state of Andhra Pradesh, as per the agreement between the parties and as per the statutory provision. 48 point and odd, and 51 and odd. 51 to Telangana and 48 for the state of Andhra Pradesh has been supplied. there is no minute dispute that there was on any day before 2017, there was minute stoppage of supply. Though it was decided by the state of Andhra Pradesh, and there was a direction to AP Genco not to supply power to Telangana. But by virtue of the provisions contained in the Electricity Act 2003, the regional load dispatch center Bangalore, through a corporation owned by the state of owned by government of India, a direction was issued to AP Genco to continue the supply. Therefore, we continued the supply. And they paid money for some time. They paid money for about 6 months or 8 months. I'll clarify all those dates when my turn comes, when I take up the issue. They paid the money. Then they suddenly stopped. We continue to request them, look, we are spending money. We are paying wages. We are buying coal. We are borrowing money for generating power. And we are supplying it to you. We are short of funds. They stopped payment. Therefore, in 2017, we stopped supply of power. And they never protested against it. They never protested. It was because of the default committed by the TS Gencos, TS licensees, DISCOMs, to whom we supplied power, as per the terms of the agreement, as per the rent, under Section 92. Though we withdrew from the PPAs. But here, Your Lordship may note one fact. These PPAs were not approved by the APERC. They were pending consideration. By the time the effective date, by the effective date, they were not approved by the APERC. They were not approved thereafter also. So we withdrew from the PPAs. That became the subject matter of APERC. But the APERC rendered an order. APERC was dissolved by the state government, AP government. Subsequent thereto with the retrospective effect. That was never challenged by Telangana government. Therefore, in my submission, the APERC order that we could not withdraw, we could not have withdrawn the PPAs, which were not approved till then, became void. Because we dissolved the APERC, which power we had under the State Reorganization Act, with retrospective effect. This GO of the government of government of Andhra Pradesh dissolving APERC was never challenged by Telangana state. But the fact remains that I take your lordship to the relevant papers at various stages of the proceedings before a subcommittee constituted by the Ministry of Home, before the Zonal Commission, Southern Zonal Commission under the old State Reorganization Act, which has no statutory power at all. It's only a recommendatory body on which my lord friend was trying to rely on. Without referring to the subcommittee constituted by the Ministry of Home for resolving, apart from other issues, this issue relating to payment of amounts due further supplied to the notified date. But whatever I have supplied after the notified date cannot be linked to the demerger issues. Demerger issues arise out of a statutory scenario. Whereas the liability of TS to pay to AP post notified date by virtue of an order issued by the Southern, by virtue of the order issued by the POCASO, which way which we obliged, we were obliged to under the provisions of the Electricity Act, failing which manner we were liable to pay penalty to the Union of. This amount, my lord, is sought to be linked to the demerger issues. That's been their steadfast stand from the beginning. After having paid the amounts due to us, the power supplied for a few months, they stopped payment. No reasons are given whatsoever. And whenever we wanted the dispute to be resolved, whenever we wanted the amount to be paid, they said, this is linked with the payments, so much amount due to us. My landlord repeatedly said, my lord, an amount of 12,000 odd crores is due. And that's the claim pending in those 2 or 3 writ petitions that are filed before this Honorable Court. On the other hand, my lord, if this Honorable Court examines the counter affidavit filed on behalf of the state of Andhra Pradesh, it would be clear, my lord, an amount of 6,000 and odd, my lord, 609 crores. After adjusting all the liabilities between the 2 states with respect to merit power, an amount of 609 crores is due to the state of Andhra Pradesh. The allegation that 12,000 crores is due merit from AP is a myth that is created, is a myth that is created to evade payment of this amount due, which is post bifurcation. I'll continue.
Yes. Yes, madam. Right.
Merits on Monday, merits.
One minute. We'll tell you what date. Yes, Mr. Vaidyanathan, Monday.
One.
25th September. 25th September. Mr. C.S. Vaidyanathan, Learned Senior Counsel, concluded his submissions. Mr.
Director Solicitor, Mr. A.R. Liberation.
Keep it on the table. As it is. It should come under the caption further hearing, right? We have said so, further hearing.